year, the Ottawa Police Service follows when protests occur. Police must respect the charter right to peaceful protest while at the same time protect the community and uphold public order. To this end, police typically reach out to protesters and work with them in advance to preserve the peace and to minimize community impact. The Ottawa Police, you will hear, followed that well-established process that had always worked with protesters this time as well, and were prepared for an event, but not for the event. What you will hear, this protest was unique in Canadian history. Police had little time to prepare. The genesis of the protest had only begun a couple of weeks before it arrived in town, and it gained momentum with time. The number of individuals and vehicles was difficult to talk about. Because although the first convoy left the West Coast on January 22nd, most of the convoys, because of their geographic proximity to Ottawa, left the day before. The largest convoy, by the time it reached Ottawa, was 40 kilometers long, thousands. That could not have been predicted. The initial response of the convoy and the initial reports that the police received were that it would be peaceful and that most people would leave by the end of the weekend. And although many people and vehicles did leave, many more did not. Some who left returned the following weekend. The protest became dangerous and the situation became volatile. This was an unprecedented situation, and it required an unprecedented response by the Ottawa Police Service, along with several thousand other police officers from across the country. All of the Ottawa Police Service officers and all of their partners, you will hear, worked tirelessly and professionally. And that integrated response by the police, led by the Ottawa Police Service and its partners, brought what had started as a protest but become an illegal occupation to a successful resolution. The Ottawa Police Service recognizes the impact on the residents and businesses in the city from the convoy, and that it was significant. What none of the intelligence predicted in the very brief period of time prior to the convoy's arrival, the level of violence, social trauma was inflicted on the city and its residents. The demonstration came to be an end. Chief Bell told the Ottawa Police Service there were lessons to be learned to make sure the events of the past are not repeated. Here, the changes have been made to how the Ottawa Police Service handles events, and lessons have been learned. The Ottawa Police Service welcomes the opportunity to work through this process.
The story that was ridiculous. Well, okay, well, we had a good talk. Now we can. Thank you very much.
Now that you're on film, you run
this
away.
This is the CBC radio. Look at this.
Now that you're live, you're going.
Yeah, yes, exactly.
You don't want to. You're wearing the brand and saying all of that.
Yeah, man. Like, we can hear you all on the audio. You were on audio the whole time over our broadcast.
I just wanted to talk to those guys.
Okay.
We had a great discussion. Now,
was it great? Was it? Was it?
Was that a great discussion?
I just saw you pointing at it. Was it? Well, was it positive? Or?
No.
So what happened?
He was harassing him for that time. Accusing him of calling him at home.
That cyclist? He just called him a fucking. He just called him a name because he walked out in front of the cyclist.
Oh yeah,
well, because he thinks he's in charge of everyone. Anyways, we're going to go back to the broadcast. Sorry, we interrupted the broadcast. The CBC radio came out and accused Tinfoil Hat Man of calling him in his home and said threatening him or something. I don't know. He's off to his medication today.
That's your national broadcaster for you.
But to be fair, he doesn't work for CBC.
No, he works for Radio Canada. Yeah, okay.
Oh,
big difference.
He he's telling me that he's the one that got shot in the parliament.
He got shot?
Yeah.
By what?
Crazy man, I went to do too.
Oh, he was in harm? You mean when Mitch Early was killed?
Went to an Afghan. Got shot up there.
Oh, okay.
Yeah, but no, here, he got shot here at parliament.
Well, that's a good
I think my colleague, Jeanette Percy.
I did this for you guys.
Freedom conflict. We would hear about the intelligence gathering process and the way that the OPP disseminated intelligence to its policing partners and the timing of sharing that information as a convoy moved across Canada. You would hear about the OPP's responsibility for highways and how it policed the areas within its jurisdiction in Ontario as a freedom convoy through Ontario. You will hear about the effectiveness and the importance of the OPP's provincial liaison team. You'll hear reference to PLT frequently throughout this inquiry. And you'll also hear about the effectiveness and importance of what we call the framework for dealing with events of this nature. These were lessons learned and incorporated from the Wash inquiry many years ago that have informed OPP practice to this day. You will hear about concepts such as incident command, public order policing, and related concepts. Even though the OPP was not the police service of jurisdiction, we'll hear about how the OPP provided crucial assistance to Ottawa, Windsor, hear about how unclear working with the Windsor Police Service and held some additional resources from other police services successfully cleared the blockade of the Ambassador Bridge. Windsor was very much a success story from the Palace 10. In Ottawa, after some delay, you would hear that the OPP took on a leadership role in coordinating resources from different police services, working with on Ottawa Police Service, the police service of jurisdiction. Specifically, you will hear about what worked well, what may not have worked as well, and potential lessons that were learned through these incidents in Ottawa, Windsor, and across the country. You will also hear about federal and provincial emergencies legislation and the extent to which the OPP relied on those authorities. The OPP has significant experience in responding to protests, blockades, and similar activities. While the emergencies legislation, in particular the provincial legislation, provided useful tools, there was sufficient legal authority in their absence to deal with the protest activities that took place over this period of time. This inquiry is a unique opportunity for the OPP to share how it responds to protests. It's an inquiry that the OPP takes very seriously, consider any and all recommendations that arise from it. The OPP is looking forward to engaging in a meaningful way to contribute to this very important public discussion. Thank you.
Very much. I'd like to then call on Peter Slowly's counsel to address the agenda.
It's Tom McCree, and together with my colleagues Rebecca Jones, Mike Stefano, Council, former Chief of the Ottawa Police Service. Chief Slowly also looks forward to assisting the important work of the Commission. In granting Chief Slowly standing, Mr. Commissioner, you found his firsthand knowledge of how the events unfolded here in Ottawa. His role in framing the response meant that he was uniquely positioned to make a contribution to your fact-finding policy process. As you've described this morning, under the terms of reference of the commission, we're required to examine the circumstances that led to the declaration of police, among other efforts of police prior to and after the declaration.
In the community. He will tell you of the pride in his work as the chief and how proud he is of the hard work performed by the Ottawa Police Service that ended in the successful conclusion of this national security crisis without the loss of life or serious injury to the public, protesters, or police. Chief Slowly knows that effective policing is only possible when a community has trust and confidence in the police service. And when the resources needed to end the occupation were present, the conditions were present and plans in place to allow police to end the occupation safely, he will explain why he elected to step aside to ensure that any lack of confidence in the Ottawa Police Service held by the community that had developed over the period of the occupation did not compromise public safety. Finally, Chief Slowly looks forward to assisting you in the part of your mandate that is forward-looking, as you indicated, and seeks to learn from the unprecedented events in Ottawa that led to the declaration of an emergency. Chief Slowly has 11 specific recommendations for your consideration that he will explain. Identify ways for government, police, and civil society to prevent, mitigate, respond to, and recover from these public order emergencies in the future. I'm grateful. Thank you.
Thank you. Okay, then I think next we should hear from the convoy organizers who are also involved in the proceedings of the commission.
Good morning. My name is Brendan Miller of Foster LLP, and I am counsel to Freedom Corp, which is an organization that represents the protesters of which attended Ottawa in January and February of 2022. My colleague, Ms. Beth Sheba Vandenberg of Foster LLP, is my co-counsel on this matter, as well as the solicitors of record, both Mr. Keith Wilson, King's Counsel, as well as Ms. Eva Chipiuk, who is counsel to the convoy. With respect to sort of everyone's given an overview of the theory of their case, it is our view that there was no justification whatsoever to invoke the Emergencies Act. The Emergencies Act requires several things. One, it could be invoked due to espionage and sabotage. Are you going to hear any evidence about espionage and sabotage? The answer to that is no. Two, it could be invoked on the basis of clandestine or deceptive foreign influence, or foreign influence that involves a threat to a person. Are you going to hear evidence about that? The answer to that is no. It also could be invoked on the basis of threats or use of acts of serious violence against persons or property. Are you going to hear evidence of violence against persons or property? The answer is no. Lastly, it can also be invoked if there is a group or persons trying to destroy or overthrow by violence the system of government of Canada. Are you going to hear evidence about individuals trying to do that? The answer is no. And the answer is that there was no reasonable and probable grounds to invoke the Emergencies Act, and that the government exceeded their jurisdiction, both constitutionally and legislatively, in doing so. Thank you.
Thank you. And now the residents group, the Coalition of Residents and Businesses of Ottawa.
Thank you very much, Commissioner. My name is Paul Champ, and I am counsel for the Ottawa Coalition of Residents and Businesses. I'm here with my colleagues, Christine Johnson and Emily Tamman. The Ottawa Coalition of Residents and Businesses are community associations of people who live in downtown Ottawa, as well as the business improvement areas of the different business sectors that were impacted by the Freedom Convoy protests in January and February. The groups came together because their interest in this inquiry, Commissioner, is simply to have the story told. We can tell you it's just blocks from here. Well, right this street, the blocks from here are the people who lived here. There are approximately 15,000 residents who live in this downtown core. People see the Parliament buildings and they think this is all government and so forth in downtown Ottawa, but there are people, there are children, there are schools. There's a public elementary school. It's about 6 blocks from here. And the impact on Ottawa for those 3 weeks of harassment, street blockages, ear-splitting air and train horns, and general lawlessness was unprecedented. The nation's capital is naturally a site for demonstrations and protests on a wide range of issues. And these protests are not simply tolerated by the people of downtown Ottawa, they're celebrated. People who live in Ottawa are very proud that they're the site of protest and government and the exercise of fundamental freedoms and democratic participation. Some Ottawa people participate in these protests sometimes they don't, but they're always happy that these events are happening. But the Freedom Convoy protests that took place here were of a shape and form that were totally unprecedented and had a severe impact on those who live and work and do business in Ottawa. Many people in Ottawa felt like they were prisoners in their own home, and they felt abandoned and they felt unsafe by the police and by all levels of government. There were breakdowns in governance here between city, province, federal government, whomever. The interest of the coalition is not to point fingers, it's to get answers and to ensure this doesn't happen again. The Ottawa Coalition is not going to take a position we don't anticipate on the Emergencies Act, but make no mistake, it was a crisis in downtown Ottawa. There was disorder, there was chaos, there were propane tanks, there were gasoline jerry cans everywhere, there were fireworks going off at all hours of the night, pinging off buildings, pinging off windows. People could not get, there was no public services, paramedics, ambulances, no buses, no taxis, grocery stores were closed. Businesses, several hundreds of businesses are closed. The Rideau Centre, the major mall in Ottawa, was closed for the first time in its history for a prolonged period of time. The people in Ottawa are still traumatized, Commissioner. They're bewildered, they're upset. And I can say, Commissioner, these 30 days that you have, we could have residents line up every day to testify, to tell you their stories. People who are elderly, people who have young children, people who have disabilities, and just anyone trying to feel safe in your own home with those horns going from 6 to 7 a.m. until 11 p.m. at night or even later. And not just like a honk honk, like prolonged holding of those air horns. 400 commercial trucks congregated in downtown Ottawa. And the people felt abandoned by their authorities. It's going to take a while for this city to heal internally. There's been a breakdown in trust in the local authorities and officials and every level of government. And we're looking forward to hearing the evidence. We're looking forward to hopefully getting some answers factually about what happened and what were the breakdowns. And you know, most importantly, that there's recommendations that hopefully come from this this proceeding to ensure that, you know, serious disruptions to people's lives living in Ottawa never occurs again, while at the same time we absolutely are protecting and celebrating and ensuring that the right to protest and assemble are not unduly interfered with in future. Thank you very much, Commissioner.
Okay, thank you. perhaps I'm about to turn to the various organizations that are also have standing. But before I do so, avant de passer aux différents.
But before I move to the various organizations with standing and who will take part.
Yeah, I'm sorry. That last fucking guy was on crack. He was talking about how people were disaffected by the horn honking. What about the disaffection from the forced vaccinations, the forced unemployment, the mandated you may not see your family orders, the stay-at-home orders? That fucking guy, I want his head.
Dun, 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 dun.
Champ there, who leads the representation for Ottawa residents, those affected by the occupation that took place, as well as the legal counsel in part for the protesters themselves. So much ahead. And as for the timeline,
right.
Also.
So we're just going to listen to this CBC cocksucker go on for a while. Nice tie, cocksucker. How many cocks can you fit in that mouth? Fucking clown.
Special coverage for you right here on CPAC. Take a listen to my conversation, again, recorded earlier with Michael Kempa. Michael Kempa is a professor of criminology at the University of Ottawa. He joins us right now. Michael, good to see you again.
Thank you. Thank you.
Now, you have been very clear in the past, you believe, or believed at least, that the government was justified in using the Emergencies Act. Why is that?
Well, it's very regrettable that it was necessary to mobilize the Emergencies Act. It was simply the case, though, that the normal chain of civil institutions...
So can you tell us why you thought it was necessary to invoke the Emergencies Act?
The federal security agencies had not managed to bring the crisis under control. There were really no options left other than to mobilize the Emergencies Act, even though it should probably have never have gotten to that had our agencies been prepared in advance.
Had they been prepared? Now, was it just a matter, though, of giving them more time to respond rather than invoking the act?
It wasn't a question of time to respond. Peter Slowly, the former chief of the Ottawa Police Service, gave very clear evidence on this last week to the Special Joint Committee.
You see, Klaus Schwab, he told me we got to invoke the Emergencies Act, and so we penetrate the cabinet, and then we invoke the Emergencies Act.
We're simply not prepared for this magnitude of protest or crisis. And most of these structural issues have still not been repaired to this day. So it wasn't a matter of time in that moment. It was more a matter of really making sure that our police organizations are organized for this type of protest. Our security organizations are asking the right questions and gathering the right information, and that we are prepared moving forward, having had to invoke the Emergencies Act once.
Okay, well, let's go back then. If the structures were insufficient, if the right questions were not being asked, why those deficiencies? Why weren't they better prepared? Was this just something that Canada has never seen before?
Canada's not seen it before. Our security agencies have not been focused on domestic, ideological, violent extremist groups, both on the far left and the far right. We had been focused on terror issues external to Canada, most especially a preoccupation with what was known as Islamist terrorism, which is different from the Islamic faith, obviously.
What's the vaccine doing to people, you fucking morons? Who are these fucking guys? Look at this. Look at this fucking schmuck.
For at least a decade,
Fucking suede jacket.
and our agencies
I'll punch you in the fucking
focused
head.
upon it. And when we saw it approaching last January and February and bedding down in Ottawa, at the borders across Canada, and especially in Coutts, Alberta, with the discovery of weapons, we were surprised by what we saw simply because we had not imagined that it was this degree of a problem in our own country.
Now, I think there's a disconnect, though, because, of course, people will see the coverage. They will hear security experts like yourself talk about the concerns around national security, the type of danger that was present. But for many protesters, those who came out to support...
Yes, down at Coots, they had a little blockade. They totally disrupted international fucking trade, and I don't at all.
They came out for. It wasn't for any other...
Look at this fucking
political or otherwise. What would
you cheese dick, you're going to fucking jail. You hear me?
To protest and freedom of expression in Canada. There were layers to this protest. There were very many thousands of people who came out to protest vaccine mandates. The problem that we have, though, is that protest and the freedom of movement of individuals does not extend to heavy machinery and trucks and blocking public roadways and preventing essentially cities from being able to do any of their business and citizens to go about their daily essentials. So we don't have an unlimited right to free movement. The police are allowed to control the flow of traffic in our society to make sure that emergency vehicles are able to get through and that citizens can access essential services like pharmacy.
It does not extend to heavy machinery and large equipment.
We don't have clear legislation in Canada.
Who is this fucking dickhead?
Between where protest is legal and
don't have an unlimited right. You don't have an unlimited right to force vaccines on people, you fucking losers. Who are you? Who do you work for? Because you're fucking fired.
To freely express their opinions or to move around in nonviolent protest.
Okay, so what are the limits? If you're pointing to the United Kingdom as an example, what limits does the UK have that Canada does not have on the freedom of assembly and to protest?
Well, the UK legislation is very clear on not using heavy machinery or other objects to block public thoroughfares, public roadways.
Associate Professor of Criminology. Oh, this guy, he's fucking... You're going to prison, dickhead!
To use as weapons in crowds. They're clearer on the limits of hate speech and speech which incites violence. We do have limits in Canada, but they are a little bit clearer in the United Kingdom. They are things that allow police to act with more confidence in breaking up protest when it does begin to cross the line into illegality, while not interfering with legal protest.
Okay, but you know, when you look at the charges that have come out of this action, they actually have nothing to do with violations of security. Instead, what we're looking at are mischief charges, nuisance charges. How do those crimes meet
fucking hate speech, eh? Is that where you're going with this?
None of the
you little four-eyed fucking cocksucking polka dot tie wearing little fucking bastard.
Question for the
I'm gonna have this fucking guy, Michael Kemper's fucking balls in a noose, along with that fucking you know, that fucking queer CBC guy. Fuck you. Fuck you both.
Period of time. So in our case, we said this time certain areas were no-go protest zones. If you were participating in those zones or donating money to what was going on in those zones, you could have your accounts frozen and so forth. These were extraordinary powers that were basically designed to break up the crowd. When we're talking about laying charges, very often, even in a situation of emergency, Crown prosecutors and police will simply pursue the simplest charges that can be laid and taken up in the courts. So things like mischief, obstructing police officers, or assaulting police officers, these are straightforward charges that are easily prosecuted through our courts that do not require very complicated trials with very difficult standards of evidence. So the idea would be the Emergencies Act was for breaking up the crowd, but then in a sense, there's no reason to crush a butterfly on the wheel. Once you have people dispersed and you've only charged a small number of people, it's very often not necessary to use the most draconian laws for criminal prosecution. You can proceed with very simple charges that do not have enormous jail times associated with them, partially for the reason that you don't want to come down too heavily on people that may have a significant amount of public sympathy if you were to unnecessarily use huge laws against them in the courts.
But does that not undermine the justification for using the act in the first place?
In a sense, it does. If there had been sufficient police officers in Ottawa with an adequate plan and procedures and policies in place to deal with a major protest such as what we saw in Ottawa, the enforcement of all of these conventional minor criminal offenses, mischief, damage to property, any forms of violence, open liquor, violation of moving violations for traffic in the city, it could have been broken up. The key being that these things were not in place. We did not have sufficient officers. We all saw OPS seeming to be hanging back, the auto police seeming to be hanging back for the justification that they said they would have been swarmed had they enforced many of these things. It got to the point where ordinary laws could not be used to break down up the crowd, and that's where the invocation of the Emergencies Act came into play. If we're ready next time, it should never again get to the point that the Emergencies Act would need to be mobilized for dealing with a protest of Canadian citizens in domestic territory.
Now, dozens of witnesses will be heard from in the weeks ahead. Is there any one or any group of particular witnesses that you're looking forward to hearing from?
They're all essential who are on the list. There was a bit of a debate. Should the organizers of the Freedom Convoy be given the platform to present their views in the inquiry? Absolutely, they should. Canadians need to hear.
The Emergencies Act was illegally called. I want this fucking guy's head. I want his skull on my mantle. As you see it, as this fucking guy is talking, I want your skull on my mantle, you expert of criminology. You're a fucking piece of shit. Speaking for the state. Nice guitars hanging on your wall. I don't think you can play one of them.
Canadians must see and hear the evidence that these groups have and judge it for themselves.
Michael, really appreciate your thoughts once again. Thank you for the time today.
Thank you kindly.
And again, that was my interview with Michael Kempa that was recorded yesterday. Mr. Kempa being a security expert as well as a professor of criminology with the University of Ottawa. And as you clearly heard, he agrees with the invocation of the act, at least in this instance when it came to the Ottawa protest. But whether the commission agrees with the justifications, whether it believes the government met the bar as to invoking the act is something that we'll be watching for. Now, the commission will hear from 65 witnesses.
He's a security expert.
That were involved in the decision.
We had reach around time last Friday, but we don't talk about that on the official state media channel. So the Emergencies Act inquiry is going to continue, and we're just going to do whatever helps Justin Trudeau.
Of where we are in the process, because we began this day, the first full day of this commission, with Justice Rouleau beginning proceedings at 9:30 a.m. Eastern as he outlined the mandate for the commission. And we have already begun to hear from lawyers that will represent the parties that have standing before the commission over the next few weeks. Now, the introduction from the lawyers as they state what they are there for will continue after the break is done, and that's what we are waiting for right now. We're in the midst of the first break of the commission's work today, and as we wait for the commission to restart, we want to bring in another conversation that was again recorded yesterday. Now, Justin Ling is a freelance investigative journalist. He has been at the forefront of the protest even before it arrived in Ottawa, explaining the security concerns around some of the parties that had been organizing the people that came. And to be clear, it is multi-layered. There were a number of different people who came out to protest, but there were some security concerns regarding some individuals. Justin Ling has more on that.
Oh, yes. I love the freelance journalists. He's totally freelance, but he's on state media.
Thanks for being here.
Thanks for having me.
Listen, as Justice Rouleau begins his work,
You know, me
I
and
wanted to
Justin
ask
Ling,
you
wink,
to
wink.
describe the protest, because there were
Super.
those who came to speak out against mandates, whole families really who came out to support protesters who they saw being sympathetic to them being sick of government regulations. But there were also more radicalized elements that you reported on. What stood out for you about who came out or who stepped forward to organize all of this?
Yeah, so I mean, from the outset, my attention was paid primarily to those who actually organized this thing, right? The influencers, the activists, the organizers who actually put out the call for people to come to the city, who have
They're radicalized. You got to say it with a lisp. Radicalized.
In some cases, built little movements of people who have organized against the vaccines, against Justin Trudeau, against public health measures, in favor of conspiracy theories and quack remedies for COVID-19. And those people are several of the names that you hear all the time. People like Tamara Leach, people like Pat King, people like Chris Barber. Some of them we're going to hear from over the course of this commission. Some of them who have been a little bit less public-facing, people like James Bowder, people like someone we actually have heard from recently, Jeremy McKenzie, who organized some of the more radical elements that you mentioned. If you look at the organizers and the influencers, the people
they were conspiracy theorists, because
people to the Capitol who
the fucking vaccine is killing people.
This crazy effort off. Those type of people are folks who have a very paranoid view of how this country operates, who genuinely believe that there is a deep state cabal that is really pulling the strings, that the vaccines are not only deadly, but have racked up tens of thousands of deaths, that the government is covering it up. These are people who believe that the government is illegitimate, has not only broken Canadian law and the Canadian Constitution, but international war crimes laws in some cases. These are people who have written manifestos calling for the government to be removed. These are the people who I've been focusing on since the very beginning. Now, just briefly, there are...
Look up here, Polyev, I'm feeling mighty rapey!
The convoy arriving in Ottawa, and more than 1,000 of others who stayed for weeks on end. These people have a litany of different grievances. Some of them have been taken in by this misinformation, some of whom just oppose lockdowns and curfews, as many people in this country did and still do. Some of these people are well-intentioned, but misled. Some of these people are radicalized. Some of these people do want to, for example, hang the Prime Minister and lock up the chief public health officers across the country. So there was a real mixed bag of people who came out to voice their support for this convoy and who enabled this ongoing occupation.
Your fucking shirt looks like my grandma's Chesterfield. Oh, great, the four-eyed guy again. We got the four-eyed guy and reach around fucking Sally here with his grandma's fucking Chesterfield on his fucking shirt.
May have already forgotten.
You fucking people are going to prison. You fucking little dickhead, fucking cocksucker, reach around motherfuckers. We're coming for you.
Where protest leaders would be named to that, governing council. Talk to us about that.
Yes, I mean the foundational document of the so-called Freedom Convoy is a memorandum of understanding written by James Bowder through his group called Canada Unity. It was the document that propelled a previous convoy to Ottawa that never really took off. It is a document that was signed.
And we interrupt the interview that was conducted with Justin Ling to bring you back to the Public Order Emergency Commission. Again, they were on their first break of the day. They're now returning to the room. And just for those who are interested in the conversation with Justin Ling, we'll bring that again later in the program today. You can also see it on our website, cpac.ca. You can also stream it on YouTube. But for now, let's go back to Justice Rouleau. He is speaking again in the commission room.
In no particular order of importance. Please don't draw any conclusions from the choice. We will start with CCLDL, CLD, CLA, a series of organizations. Mr. Del Biggio.
On behalf of the Canadian Council of Criminal Defence Lawyers, the CCCDL, and the Criminal Lawyers Association, the CLA, my co-counsel Colleen McEwen and I are pleased to have the opportunity to participate in this commission. The CCCDL is a national council made up of senior criminal defence lawyers. The council has existed since 1992 and has representatives in every province and Nunavut. The purpose of the CCCDL is to enhance, support, and improve criminal justice throughout Canada. The Criminal Lawyers Association has existed since 1971 and serves as the voice of criminal defence lawyers in Ontario and has over 1,800 members in Ontario, across Canada, and the United States. The CLA aims to educate, promote, and represent its membership on criminal law and constitutional law issues impacting defence lawyers and clients. Together, the CCCDL and the CLA have experience and expertise in bringing close scrutiny to the justification and use of government and police powers. The Emergencies Act should be used sparingly, or as a last resort, and only where credible evidence justifies its use. The public's confidence and trust in the fair and proper administration of law demands this. During the evidence portion of the commission, the CCCDL...
What's with this fucking dickhead and his advertisement? Hey, dickhead, go fuck yourself. The government is going to jail. Do you understand? They push fucking poison shots on people. Go fuck yourself. Shut your fucking cork.
Impacted the interests and protected rights of individuals. The evidentiary portion is important for transparency and accountability, and for ensuring that the use of the Emergencies Act was consistent with the maintenance of the rule of law and the Charter of Rights. We are also eager to participate in the policy portion of the Commission because beyond the specifics of this particular use of the Emergencies Act, it is important that policy issues be considered so that the balance between the exercise of government power, the exercise of police powers,
right to self-government and other protected rights under Section 35 of the Canadian Constitution. The Union of BC Indian Chiefs is a representative of Indigenous governments and First Nations in British Columbia. Its purpose is to support and promote the efforts of First Nations in BC to affirm and defend their title and rights. The Union of BC Indian Chiefs has a unique role in British Columbia and Canada and has extensive expertise in government engagement and policy development in relation to, among other things, government accountability, policing, human rights, anti-racism, and the rights of Indigenous peoples generally. With over 40 years of experience, the Union of BC Indian Chiefs is uniquely positioned to share how government's decision-making is connected to the Indigenous people's concerns relating to the convoy protests and to address the appropriateness and effectiveness of government's response in relation to those concerns. It will be important for the Commission to understand Indigenous perspectives about the events leading up to the proclamation of an emergency, as well as the use of the Emergencies Act itself. It's also extremely important for the Commission to understand and consider the unique contexts, histories, experiences of the diverse and distinct First Nations and Indigenous peoples across Canada. This includes a consideration of the historic and ongoing oppression of Indigenous peoples by the application of Canadian law and policy and the use of state force and powers. The Indian Act, land displacement and the reserve system, the residential school system, the 60s scoop, missing and murdered Indigenous women, systemic racism, the increasingly disproportionate incarceration rates of Indigenous peoples, the increasingly disproportionate rates of Indigenous youth and children in Canada's child welfare system, and the assault and apprehension of Indigenous land defenders who seek to protect their ancestral lands and sacred resources from, for example, logging, commercial fisheries, gas export, and hydro dams. State use of power is inseparable from the daily and lived experiences of First Nations and Indigenous peoples across this country. There are many Indigenous nations and Indigenous governments across Canada, and the Union of BC Indian Chiefs represents a portion of these communities. So I want to acknowledge all of the Indigenous peoples who have been impacted by this situation. I want to acknowledge the Indigenous territories where these events took place.
This is a total fucking distraction, this one. Indigenous, blah, blah, blah. Fuck off.
Who I met this morning.
This is about the Emergencies Act and it being called illegally.
Grandmother from
You're just
Yellowknife,
distracting.
and Sandra McKenzie, Cree clan mother from Sucker Creek Treaty 8. The decision of the Commission, the policy discourse before the Commission, and any policy recommendations made by the Commission will have long-standing impact for future use of federal government emergency powers. The Union of BC Indian Chiefs is here to ensure that the government's emergency powers will be used appropriately moving forward, as they may be exercised against First Nations and Indigenous peoples. Thank you.
They literally treat us like imbeciles.
I'd like to,
You motherfuckers pushed a poison on people and it was unnecessary and you're going to jail. Every apologist, every fucking straight man, this guy with the gray hair, you think you're getting out of this alive? Think again.
My name is Jason Beachman, and I'm here today as counsel for the National Crowdfunding and FinTech Association. The NCFA is Canada's largest industry association, representing crowdfunding platforms and FinTech startups. The NCFA sought the right to participate in these hearings so that it could provide a voice for these emerging industries and technologies. We are here to comment on the fact-finding and policy review functions of the Commission with respect to two issues set out in the terms of reference. First, the impact of domestic and foreign funding, including donation crowdfunding platforms. And second, the impact, role, and sources of misinformation and disinformation, including the use of social media. Our hope is that through this process, the Commission will strive to understand whether and how misinformation and disinformation about crowdfunding and cryptocurrency influenced the decision to make orders under the Emergencies Act that targeted and restricted the use of these technologies. In his expert report submitted to this commission, Professor Ryan Clemens of the University of Calgary highlighted that the temporary orders made under the Act with respect to crowdfunding have been permanently crystallized in extensive regulation of the industry under the Proceeds of Crime, Money Laundering, and Terrorist Financing Act. These regulations were exempted from the ordinary cabinet requirement to pre-publish regulatory proposals for public comment and consultation. The explanation provided for this
guy's pushing crypto.
is that the events leading to
Get the fuck out of here.
Emergencies Act
I'll choke you with that polka dot tie, you motherfucker.
waive the obligation of due process and to confer and consult. The use of extraordinary powers under the Emergencies Act raises questions. Questions of whether the ends justify the means. In the case of crowdfunding and
Dans le cas du sociofinancement et des fintech,
the end result is that laws were passed without public scrutiny or due process. This presents a cautionary tale for Canadians, and we will all benefit from scrutiny by this Commission into whether it is appropriate to deploy these extraordinary powers when the end result may be the subtle and not so subtle erosion of the rule of law. The NCFA looks forward to the Commission's efforts to examine these issues and to the opportunity to participate in that process. Thank you.
Merci, thank you. I can now call on the National Police Federation.
Yes, good morning,
Good
Commissioner
morning.
and Commission Council. Thank you. My name is Nini Jones, and I am here along with my colleague Lauren Pierce. We are both on Zoom today, and my colleague Jen Del Riccio, who is present in person. And together we represent the National Police Federation. The National Police Federation is the exclusive bargaining agent for approximately 20,000 RCMP members and reservists below the rank of inspector. The RCMP, and by extension, the NPF's members, were the source of the largest police response to the convoy and the blockades in Ottawa, as well as in every other location throughout Canada, including the BC occupation, the Alberta occupation, Manitoba, as well as assisting in Windsor. In other words, the RCMP were the police officers charged with responding to the situations created by the convoy across the country. The NPF intends to participate with a particular focus on the scope and the limits of our members' policing authority and their policing jurisdiction. And we are particularly interested in the divided jurisdiction and the issues that arose in the city of Ottawa, where police responses came from the OPP, the Ottawa Police.
This one represents the horse tramplers.
Employed by the RCMP, along with the Parliamentary Protective Services. Those are the areas of particular interest for the NPF, and we look forward to assisting the Commission and the Commissioner with those issues as they arise through this proceeding. Thank you so much.
Thank you. If I could now call on the Canadian Constitution Foundation and Professor Alford Yes, go ahead.
Thank you. Good morning, Commissioner. My name is Sujit Chaudhry. I am a co-counsel for the Canadian Constitution Foundation. My co-counsel is Janani Shanmuganathan, and we are both on Zoom, although we
I haven't even heard this clown speak yet, but I'm gonna have fun with
in
him.
person. As you indicated, Commissioner, the CCF has been granted standing jointly with Professor Alford. I would ask that we reserved a minute at the end of our remarks for him, and we would ask that you recognize him, please, when I conclude.
Well, if I could just interrupt, there's one grant of standing, and the norm is with one grant of standing, there is one council or presentation, and it's a bit unusual, and I don't think that should be the practice. The reason they were put together as one was that we streamline the process. I'm prepared to make an exception for today, but that is not because I assume you've prepared on that basis, but you should not, as a rule, proceed in that manner. If I can ask you to coordinate your presentation, whether it's Mr. Alford or you or Ms. Munaganatham, that's up to you. But I don't want it to break down into different parties. There are many other organizations that are sharing a standing, and they've all cooperated to have one presentation. So with that caveat, Mr. Chowdhury, you can go ahead on this exceptional basis today.
And thank you, Commissioner. And we did check in with Commission Council before we decided to proceed this way, and so we appreciate your forbearance in this exceptional circumstance. Commissioner Rouleau, I have 4 points to make in my introductory remarks. The first is that I would like to introduce the CCF. The CCF is a legal charity which is dedicated to defending fundamental freedoms in Canada, particularly the freedom to think, believe, and express controversial or dissenting ideas and opinions. The CCF would like to publicly express its appreciation to you, Commissioner Rouleau, for granting its standing before the Commission. Second, the CCF sought standing to assist the Commission because it will address questions that are core to our mandate. The emergency proclamation and emergency measures regulations severely restricted the rights to freedom of expression, assembly, and association. The emergency economic measures order chilled freedom of expression by deterring donations to organizations opposed to the public order emergency, such as the CCF. For the CCF, the fundamental question is whether the condition in the final clause of Section 3 of the Emergencies Act was met, that the Ottawa protests and border blockades could not be effectively dealt with under any other law of Canada, federal, provincial, or municipal. This clause codifies the requirement that the Emergencies Act is a last resort, which can only be triggered when all other legal tools fall short. Third, although the Commission will necessarily focus on recent events, a sense of history should frame how it approaches this task. The Emergencies Act is a successor to the discredited War Measures Act, which was abused during the FLQ crisis in Quebec. The Emergencies Act, especially the last resort clause, was drafted to ensure that the act could never be used by a federal government against its political opponents. For 34 years, the Emergencies Act was never used. The public order emergency of 2022 was a historic first. But now that the glass has been broken on the act, it can be used again. The act was used by this government against individuals protesting vaccine mandates, but a future government of a different political stripe could use the act in response to protests against pipelines or climate change. When the Commission asks hard questions about the act's use in 2022, the Commission must also focus on the act's potential misuse in the future and protect the right to protest, parliamentary democracy, and federalism. What the Commission says matters not just to Canada, but globally, where the use of emergency powers is on the rise. The world will be watching our work. Fourth, the CCF would like to thank Commissioner Rouleau and the Commission Council for taking on this enormous task of public service in an extremely tight timeline on an issue of singular and momentous significance to Canada. We look forward to assisting you in any way possible. Thank you.
Thank you. Mr. Alford.
Good morning, Commissioner. May I be heard?
Yes, go ahead.
Thank you. Ryan Alford, Professor of Law at the Boer-Alaskan Faculty of Law, Lakehead University. In its opening statement, the Government of Canada stated it had a reasonable basis for declaring a public order emergency. Unfortunately, a reasonable basis is not necessarily a legal, let alone a constitutional basis for assuming unprecedented and destructive emergency powers. I would like to briefly quote in part the correct legal standard in these circumstances for threats to the security of Canada that constitute a public order emergency. Quote, activities within or relating to Canada directed toward or in support of the threat or use of acts of serious violence. Not tied to serious acts of violence in some fashion, not in conjunction with or somehow associated in some fashion with, rather directed toward or in support of the threat or use of acts of serious violence. We are here to receive in public the evidence from the Government of Canada related to the correct legal standard for the proclamation of a public order emergency. And the rule of law requires nothing less. Thank you, Commissioner.
Thank you. Next, if I could call on the Canadian Civil Liberties Association.
My job to be the comic relief. So good morning, Mr. Commissioner. Good morning, Commission Council, members of the public. My name is Kara Zwiebel, and I, along with my co-counsel, Eva Krajeska, who is participating remotely, are representing the Canadian Civil Liberties Association. We will be participating primarily remotely starting next week, but do anticipate attending in person for portions of the coming weeks. And we look forward to participating in the fact-finding role of the Commission and expect to play a particularly active role in the Commission's policy phase and forward-looking functions. The Canadian Civil Liberties Association, or CCLA, is a national, independent, non-governmental organization that is dedicated to the protection and promotion of fundamental rights and freedoms in Canada. The CCLA has been engaged in this important work since its founding in 1964 and is known for taking principled stands on difficult issues that require reconciling fundamental rights with other competing interests. The Commission is aware that the CCLA has sought judicial review of the decision to declare a public order emergency and argues that the Act's legal threshold was not met and that the emergency orders that were put in place by the government breached constitutional rights in a manner that was not reasonable or justified. The CCLA's interest in the Commission's work comes from our concern about the use of emergency powers that circumvent the parliamentary processes and allow the executive branch to rule by fiat. It is a concern that has been around for as long as the organization has existed, and although the excesses of the War Measures Act are now well understood, during the FLQ crisis itself, the CCLA was one of the lone voices critical of the use of that law. As a result of that experience, the organization participated actively in the process that led to the passage of the Current Emergencies Act. In particular, the CCLA encouraged Parliament to build meaningful oversight and accountability mechanisms into the Act and to require a high and judicially reviewable threshold for declaring a national emergency. There are many issues that the Commission will be examining which are central to CCLA's work. including the lawful scope of the right to protest, the role of police in facilitating protests while protecting public safety, the relationship between policing authorities, civilian oversight bodies, and government actors, and the surveillance of those involved in dissenting social movements. More broadly, the CCLA's interest in the Commission's work goes to the core of the organization's mandate, protecting the rights and freedoms of Canadians and demanding transparency and accountability from our governments. The CCLA views the Commission as an instrumental part of achieving the goals of transparency and accountability, and our participation in the Commission's proceedings will be aimed at supporting those goals. Thank you.
Thank you. And now I'd like to call on the Democracy Fund, Citizens for Freedom, and JCCF Coalition, please.
Good morning, Commissioner. If there's no objection, I'd like to call my colleagues up from the Democracy Fund and Citizens for Freedom. We had all prepared very brief introductions of ourselves and our organizations and should come in well under the time allotted for a single party.
I won't repeat the comments I made earlier. I think you're well aware that from now on it will be one presentation rather than three. And for today, I'll make the exception I made in the previous case. Go ahead.
Absolutely. Thank you very much. I'm Rob Kittredge. I represent the Justice Center for Constitutional Freedoms. And since 2010, the Justice Center has defended the fundamental rights of Canadians through pro bono litigation. A team of Justice Center lawyers were on the ground in Ottawa for the duration of the protests here, and our lawyers have been and continue to be involved in much of the related litigation. We look forward to continuing to defend the rights and freedoms of Canadians here at this inquiry and holding the government to account on its invocation of the Emergencies Act. It likely comes as no surprise that we view the invocation of the Act to have been an unjustified infringement on the fundamental rights of Canadians. I'm joined here today by my co-counsel, James Manson, and my co-counsel, Hatem Kir, is following online. We will each be here in person at various times throughout the inquiry, and I'll turn it over to my colleagues at the Democracy Fund and Citizens for Freedom.
Okay.
Thank you and good morning. My name is Antoine Dailly, counsel together with Amanda Armstrong to Citizens for Freedom, representing a not-for-profit organization representing the interests and perspectives of the peaceful demonstrators in Windsor, Ontario. We are here to assist the Commission in fulfilling its mandate, particularly its fact-finding function as it relates to the protests that occurred in Windsor, which culminated in the widely publicized demonstration near the Ambassador Bridge, and the various corresponding responses by the various levels of government and law enforcement. Citizens for Freedom is here to advance the interest of truth and transparency and to assist this Commission in producing a balanced and accurate public record.
Good morning, Commissioner. Good morning, everyone. My name is Alan Honor, and I am the Litigation Director for the Democracy Fund. The Democracy Fund is a registered charity and a civil liberties organization. As you've heard, we're sharing standing with the JCCF and with Citizens for Freedom. Our interest in this inquiry arises from our legal work. In February of 2022, we sent lawyers to Ottawa and to Windsor to provide demonstrators with legal information about their rights when protesting, as well as the limitations of those rights. Around the same time, we were granted intervener status as a friend of the court at the Superior Court of Justice in Windsor over the Ambassador Bridge injunction proceeding. Currently, we represent dozens of persons who have been criminally charged in relation to the protests at Ottawa, Windsor, and Coutts. And we represent thousands of others who've been charged under the Quarantine Act or provincial offenses related to the pandemic. We've also brought applications before Superior Courts and the Federal Court of Canada, challenging laws related to the pandemic. Our objective is to participate in the fact-finding process of this inquiry particularly as it relates to uncovering the truth about why the federal government invoked a public order emergency and how they used their powers. From our perspective, the government did not meet the requisite legal grounds to invoke a public order emergency for the same reasons you heard from Counsel for the Freedom Corps. It follows that the extraordinary measures the government invoked were therefore inappropriate and indeed outside their jurisdiction. Our questions and our submissions will focus on these central issues. Thank you.
Okay, thank you very much. Now, I understand there are three other parties to the proceedings who have, in some cases, more limited involvement and interest in the proceedings, either for mostly the policy end. And they're not present today either in person or by video, as I understand it. They would be the government of Manitoba, which I referred to earlier, as well as the Canadian Association of Chiefs of Police and the Insurance Bureau of Canada. So that, with those three, that makes up the roster, if you like, of parties with standing. I want to just first say I'm grateful to the parties for the assistance that they have given the Commission to date, and for what I hope will be continued assistance. Anyone who had the illusion that this would be easy and uncontroversial, I think the presentations have started to lay out some of the differences and issues. It's a challenge, but it's one which the Commission is eager to take on. Ça nous fait certainement plaisir d'avoir.
We are quite happy to have these various parties who have obtained standing before the Commission, and there are certainly many perspectives, but they're all welcome to try to address all the issues and challenges to come to a solution. And the Commission is really happy to take on this challenge.
I think we'll now turn to the beginning of what I will call the evidentiary phase. And the first is more through the presentation, as you've heard, as I understand it, of various reports. So I'll turn it over to Commission Counsel now to take us to the next step.
Thank you, Commissioner. To begin, I would ask our Senior Commission Counsel, Daniel Shepherd, to present and deduce into evidence an overview report on the emergence of COVID-19 and the various public health measures implemented in Canada in response to it.
Mr. Commissioner, parties, members of the public, good morning. My name is Daniel Shepherd. I am Senior Commission Counsel with the Public Order Emergency Commission. Today, we will be introducing into evidence 3 overview reports, and we anticipate that additional overview reports will be put into evidence in the days and weeks to follow. The first is a report on the COVID-19 pandemic and public health responses. Next slide, please. Because we're going to be spending some time today putting overview reports into evidence, I'd like to take a moment to discuss with members of the public what an overview report is and how it works within the Commission. You have already heard that the timelines that the Commission is working under are tight, and that not every witness that the Commission might hear from will in fact be called. There are large bodies of evidence that exist, often in writing, and entire topics.
Too many lawyers, not enough fucking doctors.
But it would be impracticable to call live evidence in order to put it before the commissioner. Previous commissions of inquiry have adopted the procedure of overview reports, documents created by commission staff that collect, collate, and summarize large bodies of information into documents that may be more or less concise, so that they can be reviewed by the commissioner, the parties, and the public to understand a particular area of relevance to the commission. The Public Order Emergency Commission has adopted this procedure, and for those who are interested in technical details about how overview reports work, reference can be made to Rules 41 through 45 of the Commission's revised Rules of Practice and Procedure.
I'm going to collate the balls of the guilty into a guilty guillotine. They're going to be collated.
They have been circulated to the parties, and we've invited their comment. And for those parties who have provided comment to the overview reports so far, I would like to express the thanks of the Commission. While not all comments have been accepted or are necessarily reflected in finalized overview reports, the feedback that has been provided has been invaluable in ensuring that the Commission puts forward what it believes are high-quality documents before the Commissioner that he can rely upon. Once overview reports have been finalized and are introduced, they do become evidence before the Commission that may be relied upon by the Commissioner and the parties. However, it is important to note that simply because an overview report has been prepared by Commission counsel does not mean that the Commissioner necessarily will accept its contents. Rather, an overview report is, like all other evidence, information before the Commissioner that he may or may not choose to rely on.
Where'd you learn how to talk like that? Some Panama City sailor want a hump bar?
And are entitled to challenge its contents. Moreover, in areas where an overview report may not capture relevant information, parties, and indeed Commission counsel, are free to supplement the information contained in them through the ordinary process of the factual inquiry. Next slide, please. With that general introduction out of the way, I would now like to present COM-OR2, the COVID-19 pandemic and public health responses. This overview report summarizes publicly available information about the COVID-19 pandemic around the world and in Canada. The Commission anticipates that a great deal of evidence that it will be hearing will be made in reference to the pandemic and public health measures implemented by various Canadian.
With that general introduction out of the way,
the report attempts to provide context so that when those discussions take place and that evidence is heard, the Commissioner.
You want to know how we got this far down the fucking road? We're led around by these fucking numbskulls.
Public health measures
Get to the point, you fucking dickhead.
And what statements about the current public health system around the world and the pandemic were at different points in time. It therefore provides information not only about the pandemic itself and about public health measures, it also provides information about vaccine development and particular measures adopted by Canadian governments and different jurisdictions with respect to COVID vaccines. Next slide. The overview report.
I'd like to choke you to death with your shiny silk fucking tie. You hear me, you male pattern baldness, COVID-19 health measures, fucking legal dickhead.
Of the COVID-19 pandemic. It does so in two ways. First, it provides a summary overview of international information about the spread of COVID-19 around the globe. And then second, provides background information about the emergence of COVID-19 in Canada. Next slide. On the international side of things, this overview report provides information about the original emergence of a novel coronavirus in late 2019 and its rapid spread throughout the world. It also provides background information about public health declarations and surveillance conducted by organizations, most notably the World Health Organization. This includes the January 30, 2020 declaration.
This narration is for entertainment purposes only.
National concern.
Entertainment purposes only.
2020 declaration by the World
Nobody
Health
go
Organization
after
of
Dan
COVID-19
Shepard here
to
and
be a
try to
global
choke him with his
pandemic.
silk fucking tie.
Next slide, please.
Although, I don't know.
In Canada, this overview report discusses
Like
two
to
main
tighten it.
timelines. First, it deals with when COVID-19 first emerged in different provinces across the country. With the exception of early provinces such as Ontario and British Columbia, and the territory of Nunavut, which was spared any infections until later in 2020, the overview report notes that most provinces began to be impacted with infections in late February through mid-March. This overview report also outlines when each province and territory first declared a state of emergency under a variety of public health and emergency management statutes in respect of COVID-19. You'll note from the slide that each of these jurisdictions declared some form of emergency throughout March of 2020.
I have taken shits more interesting than this fucking guy.
The second part of this overview report, which is found in paragraphs 40 through 108, deals with what we term as the initial public health measures. Next slide, please. Spanning pages 16 through 50 of the overview report, this is a lengthy section.
Is that corn in there?
It's important for Commission Council to emphasize this is not a comprehensive list of every public health measure that was implemented within Canada. Rather, it is limited in a couple of different ways. First, this overview report focuses on public health measures that were adopted from the early declarations of emergency in March 2020 up until the point in time when COVID vaccines began to be approved for distribution and marketing in Canada. Secondly, this section of the
Okay, I don't know if he's for or against this. I just say fucking hang him now. Let's go.
Public health measures adopted by governments at the provincial and territorial level. Notably, it does not address public health measures adopted by other levels of government, such as municipalities or Indigenous governments. Finally, even within those confines, the overview report does not attempt to outline each and every public health measure adopted within the first year of the pandemic. That would be impossible and would turn the overview report into a largely useless document. To put this in context, in Ontario, the jurisdiction...
If you would all find the commentary, you know, I don't know, incendiary, maybe fucking offensive, go watch it on CPAC.
Orders in council specifically dealing with measures in respect to the pandemic. And while I have had the pleasure of reading each and every one of them, it would not necessarily be the best use of the Commission's time to go over them in an overview report. Instead, this overview report focuses on 6 particular types of public health measures that were adopted broadly throughout Canada and had significant impacts on the way Canadians lived their lives. This includes restrictions on travel, both in terms of barriers to entering provinces and territories or requirements to self-isolate, school closures, and other...
Guess what, dickhead? You're not particularly using the fucking time of the general public very well. You should join Hair Club for Men and maybe just shut the fuck up. Sit down next.
And outdoors. Closures of businesses and other locations, such as the shutdown of indoor dining or prohibitions on use of outdoor recreational amenities. Curfews and stay-at-home orders, measures that, while adopted less frequently throughout Canada, did have significant impacts by restricting individuals' rights to leave their home during particular periods or times of the day. And finally, masking requirements, obligations imposed on individuals to wear face coverings in a variety of settings. Next slide. The third portion of this overview report deals with vaccine approvals in Canada. It is found in
Who invited this guy to speak?
through 123 of the overview report. This section of the overview report deals with two broad issues. First, the overview report discusses the process whereby vaccines were considered and approved by Health Canada. Second, it deals with the actual approvals that were in fact made and the vaccines that became available at different points in time for marketing and use. Next slide, please. With respect to the drug approval process, the overview report discusses in very general terms how drug approval operates within Canada under the Food and Drug Regulations, a regulation that is made pursuant to the Food and Drugs Act. Under the Food and Drugs Act, however, the Minister of Health has the authority in section 30.1 to make something referred to as an interim order. An interim order can be made, and this is the statutory language, quote, if the minister believes that
I object to the fact CPAC is not rebroadcasting the slides.
significant risk, direct or indirect, to health, safety, or the environment. The overview report discusses that on September 16th of 2020, the Minister of Health made one such interim order with respect to COVID-19 vaccines. The interim order respecting the importation, sale, and advertising of drugs for use in relation to COVID-19 contained a number of rules that were followed by Health Canada in the assessment and ultimate approval of a series of COVID-19 vaccines. Two procedural characteristics of the interim order are of particular note. The first is the rolling application process. In the ordinary drug approval process, Health Canada expects proponents to put forward all relevant clinical...
Yeah, none of those rules were demonstrable. You had no fucking proof. You had a case-demic. You had no mortality outside of standard flu. And then you gave people shots in December 2020 through 2021. And now the leading cause of death is unknown, you motherfuckers.
And prior to final approval. The second procedural alteration was pre-positioning, a measure that permitted the importation of drugs and its positioning throughout Canada, so that in the event a vaccine were approved, doses would already be located at several locations throughout the country. At this point, I'd like to pause to note that on March 17th of 2021, the interim order expired.
Yeah, Dan, I don't know whose side you're on, but I vote fucking...
amendments to the Food and
You
Drug
can hang
Regulations
with the
to
rest of them. I
incorporate
don't give
some
a fuck.
aspects of the interim order into the ordinary regulatory regime. Next slide, please. The interim order also set out the approval standard for the Minister of Health to apply when approving drugs for use with COVID-19. The standard, in relevant part, was that the minister had to have sufficient evidence to support the conclusion that the benefits associated with the drug outweigh the risks.
Just because you have so many fucking slides, Dan, I vote you hang. That's
The
it.
necessity of addressing the urgent public health need related to COVID-19. Applying this standard, Health Canada approved a series of drugs for use within Canada. By today, there are currently 6 drugs that have gone through the approval process that began in December 9th of 2020 and most recently occurred on February 24th, 2022 with a drug put forward by the company Medicago. Next slide, please. The fourth and final section of
Let me
the
guess.
report
Remdesivir?
specifically related
Was it
to
ivermectin? Was it hydroxychloroquine?
104
Chloroquine?
through 100
Quinine for
of the
1,000, Alex.
Next slide. Once again, the overview report does not mean to be entirely exhaustive. The purpose of this section of the overview report is to identify certain key public health measures that were specifically tied to individuals' vaccination status. The focus of this section of the overview report is on rules imposed by governments. Rules imposed by other types of actors, such as employers, of their own accord.
Dude, you put the whole country to sleep.
In the overview report.
Look at you in your silver fucking suit and your silk tie.
Much like the section dealing with early public
Hang 'em.
health measures,
That's what I say.
the
Hang 'em.
Commission has also focused on a particular subset of public health measures connected to vaccine status. It is focused on access to places, requirements for work, and limits on travel and movement. Next slide.
This commentary is for entertainment purposes only.
Report discusses
Entertainment purposes only.
implemented by government that
You know,
tied an
you
individual's
can either watch
ability
paint dry, or you can
to
watch
access
paint dry
particular
with a really
place,
bad
venue,
comedian
or
in the
service
background.
to
Really
their
bad
vaccine
narrator.
status or their willingness to provide proof of their vaccine status. Within this section, the Commission notes that there were a range of different types of public health measures adopted by different governments. So to simply provide an example to show some of the ranges of options adopted by governments, Alberta implemented something called the Restrictions Exemption Program.
Look out, Pierre Polyev, I'm feeling mighty rapey.
In time, many types of businesses in Alberta were subject to particular forms of public health measures, such as masking requirements, limits on the number of people who could be physically present in a venue, or social distancing obligations. Under the Restrictions Exemption Program, certain types of businesses had an option. They could continue to operate under the pre-existing public health orders, or they could opt into this system, which would relieve them of the obligation to comply with several of them. However, in order to participate in the Restrictions Exemption Program, qualifying businesses were required to check vaccine status of those attempting to access their venues, and
Blah, 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 all of which was unjustified. Where's your mask, you
was
fucking
adopted in
dickhead?
Ontario, pursuant
How
to
many cocks can
originally
you fit in that mouth?
Regulation 645/21, though amended several times thereafter. Under this approach, the Government of Ontario imposed mandatory obligations on businesses to require that anyone accessing their premises show proof of full vaccination. There were no opt-outs that were provided. Next slide, please. The overview report also deals with a number of measures related to employment and work. In this area, governments adopted a range of different rules and measures that linked individuals' ability to engage in certain types of work to their vaccine status. These measures were adopted in a variety of different ways. Some were applicable solely to the public sector. Others captured private sector employers as well. Some measures applied directly to workers. Other measures applied to employers and required them to implement particular policies. And the requirements under different programs varied dramatically. Some were simple obligations on workers to become vaccinated to access workplaces, and others provided a variety of alternatives. Again, solely by way of example, we've provided two on this slide. The Saskatchewan government adopted a pair of regulations, the Public Employers COVID-19 Emergency Regulations and the Employers COVID-19 Emergency Regulations. The former imposed an obligation on all public sector employers to implement.
All right, people, that's it. Start digging holes. Get lime
either
and spades.
Become fully vaccinated by a particular point in time, or else to undergo weekly testing in order to access the workplace. The latter regulation applied to the private sector. It imposed no specific obligation on employers, but did give employers the legal authority to impose this type of policy on their workforce.
This guy's first.
As a contrast, the Commission has put on this slide Newfoundland's approach in its mandatory vaccination policy. This policy, which was applicable to public servants,
right in the fucking hole,
and vendors with the government, required workers to become fully vaccinated by December 17th of 2021. Those individuals who chose not to become vaccinated by that date were told pursuant to the policy that they could be placed on a leave of absence without pay. Next slide. Thank you. The third and final area of focus in the overview report in this section deals with travel and movement. While some
Yeah, we lived it, dude. We remember.
imposed rules
You're reiterating your own fucking funeral.
Individuals' vaccine status, the bulk of rules in this area were implemented by the federal government under a range of statutes, including transportation legislation, such as the Railway Safety Act and the Aeronautics Act, and also, and of particular significance to the evidence that we anticipate hearing in this inquiry, pursuant to the Quarantine Act. As many
Dig the fucking
remember,
hole.
for much of the early days of the COVID-19 pandemic in Canada, Canada's borders were largely closed to foreign nationals who were attempting to enter for optional or discretionary purposes. However, starting between August 9th and September 7th of 2021, Canada began to implement rules permitting individuals to enter the country for optional or discretionary purposes as long as they were able to show proof of being fully vaccinated.
All right, freedom fighters, we're looking for backhoes. We need to dig a hole that's big enough for about 10,000 people. It's going to be filled with guys like this wearing fucking these cheap-ass silver fucking suits, silk ties. They don't shut up. They just
rules were contained in a variety
refuse
of
to
orders
take
under the
accountability.
Quarantine Act and were often
Backhoes.
applicable in a somewhat complicated fashion. However, taken together, the effect was that for much of the pandemic, commercial truckers were able to cross the US-Canada border without regard to their vaccine status. Indeed, for much of the time they did so, there were no vaccines available. Those individuals crossing the border could be exempted from a variety of otherwise applicable measures under the Quarantine Act, such as the obligation to quarantine, as well as certain rules with respect to testing. Next slide, please. The Commission anticipates, however, that a series of changes that began to be announced in October and November 2021 played a significant role in the circumstances that led to the proclamation of a public order emergency. First, starting in October of 2021, the government of the United States of America made an announcement that starting in January of 2020, all inbound foreign nationals entering the United States via land or ferry crossings would be barred from entry if they were not fully vaccinated, even if they were entering for an essential purpose. A little over a month later, on November 19th.
I think they're hoping he talks long enough that we all commit suicide before we decide to stand up and arrest these
New rules
motherfuckers.
would apply at the border under orders made under the Quarantine Act. The effect of the announced changes was that essential service providers, including truck drivers, would have to be vaccinated to enter Canada in many circumstances. Unvaccinated foreign nationals would be barred from entry. Canadians and others that had a special legal entitlement to enter the country would still be allowed entry. However, they would no longer be exempted from particular public health measures, such as the requirement to quarantine. On January 12th of 2022, a spokesperson with the
I think it's time to mandate lethal injections for
Canadian commercial
COVIDians.
truckers would be allowed to enter Canada across international borders without the obligation to quarantine. However, the next day on January 13th, the Government of Canada indicated that that statement was made in error. The government reiterated that the previously announced new measures at the border that would apply, including to commercial truckers, though not exclusively, would come into effect on January 15th. And that is essentially where the overview report ends, as the Commission anticipates that a great deal of the evidence that it will hear will deal with events taking place in early and mid-January of 2022, influenced in part by some of the measures outlined in this overview report. Next slide. For parties with standing at the Commission, this overview report is available for review in the participant database. For members of the public who wish to learn more about the topic covered in this overview report, it will shortly be made available on the website for the Commission at www.publicorderemergencycommission.ca. Mr. Commissioner, parties, members of the public, I thank you for my time. And that is the presentation on this overview report.
Thank you, Mr. Shepherd. I wonder, is it appropriate at this point to mark that as the first exhibit?
I'd ask that to be done.
Okay, so Madam Registrar, could you enter the overview report as I take it it's Exhibit 1? Okay, so that'll be marked as Exhibit 1. Thank you very much.
Thank you, Commissioner. The next presentation will be made by Commission Counsel Stephen Armstrong.
Hallelujah, it's over.
Present into evidence a second overview report entitled Early Protests, Activities, and Legal Challenges Relating to Public Health Measures.
Go ahead.
All right, I'm another civil servant, and I'm going to give you a second overview report if the first one didn't make you want to kill yourself already.
I'm here today to present the overview report on early protest activities and legal challenges. This overview report summarizes a sample of protests and legal challenges relating to public health measures taken in response to the COVID-19 pandemic, and the timeframe is primarily 2020 and 2021, although we'll also touch on 2019 and 2022. This report is intended to provide some high-level context to the very detailed evidence that we will hear in the coming weeks. What this report describes is the development over time of what could fairly be described as a mass protest movement against COVID-related public health measures.
Yeah, I've heard enough. Guilty. Hang
The
him.
overview report is not to investigate the merits or demerits of any particular measure or of any particular protest. The report also addresses some of the legal challenges brought against these public health measures. And again, it's not an investigation into the merits or demerits of any piece of litigation. Let me also say a few words on methodology. This report was compiled based on publicly available news sources that are indexed on the internet. We made a real effort to search for a variety of sources, and we tried to cover all of the regions in Canada. And given that broad scope, this overview report is not an exhaustive catalog of all protests or all court challenges, and the absence of any event should not be taken as a suggestion by the Commission that it's irrelevant or less relevant. We've also made an effort in this report to just stick to the facts, the raw facts, the places, the dates, and numbers without any extra color. So without further ado, I'm going to move through the report in chronological order. So I will start at the beginning. Pages 5 to 6 of the report address a precursor event called the United We Roll convoy. On February 14th, 2019, a convoy of truckers known as United We Roll left Red Deer, Alberta, bound for Ottawa to protest the federal government's energy policies. Around 170 trucks of varying sizes left Red Deer as part of the convoy. Arriving in Ottawa on February 19th, 2019, the convoy participated in 2 days of demonstrations on and around Parliament Hill before dispersing. A Facebook page remains active, although already discussed the onset of COVID and the public health measures that were taken. and protests began pretty soon after those public health measures were adopted. There were protests reported from major centers such as Toronto, Vancouver, Edmonton, Calgary, Winnipeg, Saskatoon, and Ottawa in April of 2020. And eventually we saw the beginnings of what appeared to be sort of loosely coordinated national protests by the summer. And so on, for example, July 19th, 2020, protests were held in cities all across Canada, and it was reported that these were part of a coordinated march to unmask movement opposed to mandatory masking. And momentum seemed to have grown, or seems to grow from there as the protests grew in scale. On September 12th, 2020, for example, it was reported that several thousand people turned out to protest mask mandates and other measures in Montreal. As another example, in October of 2020, protesters rallied against lockdowns and other public health measures in downtown Toronto, and it was reported that around 1,500 people were in attendance. And these protests were by no means limited to the big centers in Canada. For example, on November 7th, 2020, as many as 2,000 people marched through Aylmer, Ontario to protest public health measures. And it was reported that the protesters included many people from the town's large religious communities. And moving towards the end of the year, just another example, on December 19th, 2020, hundreds of people marched through Calgary and as well as through Montreal. And CTV News reported from Montreal that the protesters were marching in opposition to public health measures introduced by the Quebec government. So turning to pages 10 to 28 of the overview report, this addresses events as they continue through 2021.
Did he just say hundreds marched in Calgary in September? Because it was 10,000 plus.
And it was reported that protests were held that same day, January 9th, 2021, in Montreal, Sherbrooke, and Quebec City. Protests were also reported in January and February in Moncton and Halifax, and as well across the country. And these protests really seem to pick up speed and reach a crescendo in the fall of 2021, overlapping with the federal election of that year. As well, in 2021, of course, as my colleague mentioned, was around the time that mass vaccinations became available. So new measures were introduced and protests continued in response to those new measures surrounding vaccination. And so going to the fall, from August 30th to September 5th, 2021, protesters demonstrated against vaccine mandates outside hospitals in major urban centers all across Canada, including St. John's, Newfoundland, Montreal, Ottawa, Winnipeg, Victoria, and Vancouver. Thousands of people were reported to come out and attend these protests right across the country. And the next weekend as well, on September 13th, 2021, protesters demonstrated across the country, including at Toronto General Hospital and in Barrie and London, Ontario, and various places across the country. And this was part of the protests organized by the Canadian Frontline Nurses. And then moving into the later part of the year is when the border measures for truckers and for other persons were announced in November, as my colleague discussed. As well, in November, Canadian Border Service Agency officers stopped a truck driver by the name of Bridget Belton at the Windsor-Detroit crossing for failing to wear her mask. And she posted a video discussing the event on TikTok. And in the video, she voiced frustration and emotion with public health measures. She would later connect with Chris Barber on social media, and these people played a role in organizing the convoy to Ottawa. So further protests continued into December 2021 and the new year. And then in the report from pages 29 to 32, we provide a very basic skeleton of certain events leading up to the arrival of the Freedom Convoy in Ottawa in January of 2022. And it's in January 2022 that we see the development of the Freedom Convoy idea and its launch. On January 13th, 2022, Chris Barber, Bridget Belton, James Bowder, and others attend a Facebook Live event hosted by Pat King. The group discussed routes and logistics for the Freedom Convoy before an audience that reportedly reached 3,000 viewers at one point. On January 14th, 2022, Tamara Litch created a Facebook page and GoFundMe campaign for the Freedom Convoy. On January 22nd and 23rd, 2022, contingents of the Freedom Convoy departed from various points in British Columbia for Ottawa, and 2 other convoy contingents were planned to depart from Enfield, Nova Scotia and Windsor later on in January on the 27th. As of January 5th, 2022, the GoFundMe campaign had raised more than $4.5 million. News reports covered the progress of the convoy on a daily or near daily basis as it crossed the country. Thousands of trucks and thousands of participants were reportedly participating in the convoy as it made its way to Ottawa. Freedom Convoy participants arrived in Ottawa on or around January 28th and 29th, 2022. And that takes us up to the subject matter of this hearing. And we anticipate that further evidence on the origins, development of the Freedom Convoy, the protests, and blockades will be adduced during these hearings. So, Mr. Commissioner, that's the overview report.
Okay, thank you. I take it this should be the next exhibit, Exhibit 2?
Sir.
Yep, okay, thank you. And I'm Registrar. This will be marked as Exhibit 2. Okay, next.
Thank you, Commissioner. I'd now like to ask once again our Senior Commission Counsel, Dan Shepherd, to present an overview report consisting of a timeline of key events leading up to the invocation of the Emergencies Act.
Hi, everyone. Long time no see. My name is Dan Shepherd, and I'm Senior Commission Counsel with the Public Order Emergency Commission, this time to present an overview report entitled Timeline of Certain Key Events. Next slide, please. This is COM OR 704. The purpose of this overview report is somewhat different than the other ones that have been produced by the Commission. Whereas other overview reports are being put forward primarily as a means by which individuals can understand background information that's relevant to the evidence that's going to be heard, this overview report is intended to serve more as a tool. It'll become fairly clear as evidence gets heard in these proceedings that events were taking place across the country, often within compressed rapid timeframes, often in different parts of the country in parallel. As individuals hear evidence about particular events, it may be useful to be able to step back and take a broader view about what was happening Canada-wide. This overview report is intended to therefore serve as something of a reference tool to help put the evidence that will be heard in its chronological and spatial context. You've heard me say with respect to the last overview report that I presented, these are not exhaustive. That is very true for this overview report. If this overview report were to recount every relevant event that took place throughout the events leading up to the proclamation of a public order emergency, then the bulk of the Commission's report would already be written. This is necessarily a highly reduced timeline that deals with only some events that may be useful for participants and members of the public to have in mind when they hear the evidence that will be put before the Commissioner. I want to emphasize, therefore, that the absence of any particular event from this timeline is not a signal that the information is in any way less relevant or irrelevant. Rather, these are only some of the events that the Commission thought would be useful to be contained in a single document before all the parties and available to the public. Next slide. So as a timeline, it is unsurprisingly organized chronologically. Within that chronological organization, the events are also subdivided by either location, when we're dealing with the event that took place in a particular space, or by jurisdiction, when we're dealing with decisions that are more appropriately tied to a particular type of authority, like a level of government. The idea is that this will permit the reader to get a rapid sense of where different events were taking place simultaneously in different locations. It's also important to note, as you read the overview report, that the actual events that are being identified are set out in very succinct and neutral terms. The purpose of the overview report is not to provide detailed information about any particular event, but rather to flag the existence of an event. The Commission anticipates that evidence will be heard on most, if not all, of the events identified in this overview report. In terms of the report's scope, it captures the period beginning November of 2021 and ending in April of 2022. However, the focus of the timeline really are events that take place between January 13th and February 24th of 2022. While the time periods before and after are covered to a certain degree, it is within that narrower time frame where the overview report provides something of a day-by-day account of events that were taking place throughout Canada. Next slide. Now, we are a little bit ahead of schedule, and so I'm tempted to simply read the overview report into evidence, but again, I'm not sure parties would necessarily enjoy that. And so instead, I'm going to take what I've already told you is a already non-exhaustive list of events, make it a little bit less exhaustive by just pointing out some of the events that are actually covered, divided into some rough time frames. I mentioned that the overview report does begin in 2021 with some things what we could style pre-convoy events. This would include, for example, what Mr. Armstrong had already discussed in terms of posts on social media that attracted particular attention with respect to public health measures and border crossings. What I have previously discussed with respect to the last overview report in terms of government announcements relating to border measures and public health measures, as well as to some predecessor protests and events that may be relevant to the circumstances leading to the proclamation of a public order emergency, such as the Operation Bear Hug convoy that took place in Ottawa in early December of 2021. Next slide. The overview report goes on to discuss what can be styled as convoy preparation, both in terms of those individuals involved in the convoy itself, but also preparation taking place by other actors throughout Canada. This includes the events that Mr. Armstrong has already referred to in terms of meetings taken online between different organizers. We also see on January 13th of 2022, the first time that the phrase Freedom Convoy is mentioned in a Project Hendon report. The Commission anticipates that it will hear a fair bit of evidence with respect to Project Hendon, what it was, what these reports were, what they contained, and how they were shared and acted upon. Many parties have made reference to crowdfunding and the funding of protest activities. The overview report also talks about certain actions taken with respect to efforts by organizers to raise funds in support of the Freedom Convoy, such as the January 14th creation of the Freedom Convoy 2022 crowdfunding campaign on the GoFundMe platform. The overview report also then discusses the actual departure of convoy participants from locations across Canada and what different individuals were doing in terms of responding to that, including communications within governments and police services. Next slide. The next portion of this overview report deals with the early protests taking place in Ottawa and a series of events occurring simultaneously in other parts of the country. On January 28th of 2022, convoy participants began to arrive in the city of Ottawa. And at the same time, levels of government began to respond, including the Government of Ontario making requests for federal assistance for access to certain spaces to be used for police staging. It's during this period of time in which the overview report also identifies the emergence of protests at various locations along the Canada-US border and in other major jurisdictions within the country, including provincial capitals. It covers early protests taking place in the city of Windsor that were styled as slow roll protests designed to impede, although not block traffic. A blockade that took place near Coutts, Alberta, and other protests in provincial capitals where individuals and vehicles protested a variety of public health measures. These events were largely public. The overview report also captures certain events that, while significant to the circumstances leading to the proclamation of a public order emergency, were not taking place in the public eye. Events such as the January 30th creation of the Freedom 2022 Human Rights and Freedoms Nonprofit Corporation, and briefings taking place within municipal government discussing the possibility of seeking injunctions in response to protest activities. Next slide, please. Moving into February, this overview report deals with what we can style the protests continue and spread, as the Ottawa protests continue to the surprise of some, and protests taking place in other parts of the country expand and become more frequent. Events that are summarized in this part of the overview report include highly notorious events such as the release of $1 million by GoFundMe, comments made by the Ottawa Chief of Police with respect to policing solutions for the Ottawa protests, and changes in the Coutts border blockade. It also deals with an increasing number of protests taking place now in locations such as Toronto, Winnipeg, and Regina. Also canvassed during this period of time are continued interactions between federal, municipal, and provincial governments, such as the Government of Alberta's request for federal assistance to gain access to military tow trucks to be used in the context of the Coutts protests. And finally, with respect to Windsor, it captures the February 7th blockade of the Ambassador Bridge. Next slide, please. Moving into mid-February, this timeline deals with how protests continued and the emergence of new responses from a variety of actors. Examples of this were the February 7th injunction obtained by class action litigants in the city of Ottawa designed to prevent the honking of horns by truckers, the arrival of an integrated planning team that brought OPP and RCMP planners to the city of Ottawa. It dealt with requests for federal assistance by governments such as the Government of Windsor. And responding to some of the previous events with respect to online crowdfunding, it also reviews steps taken by the Government of Ontario to restrain access to those funds as proceeds of crime. Notably in this period, this overview report also notes the first meeting of the Incident Response Group, or the IRG. The Commission anticipates that the Commissioner will hear a great deal of evidence on what the IRG is and the particular role it played in federal decision-making with respect to the declaration of a public order emergency. Next slide, please. The overview report then moves to February 13th and 14th, being the immediate period of time before the declaration of a public order emergency and the actual decision itself to invoke the Emergencies Act. It covers events taking place in Windsor and in Coutts, and also deals with both key meetings that took place at the federal level and between different levels of government. Next slide, please. The overview report then goes on to recount events that take place during the proclaimed public order emergency and the events leading up to the revocation of that proclamation. This includes changes in the senior leadership of the Ottawa Police Service, the creation of the Emergency Measures Regulations, the EMRs, and the Emergency Economic Measures Order, or the EMO, pursuant to the Emergencies Act, the clearance of blockades at Emerson, and the influence of further injunctive activity before the courts. Finally, this section of the overview report chronicles parliamentary debates and the ultimate decision to revoke states of emergency that existed at the federal, provincial, and municipal levels. Next slide, please. Again, for the parties, this overview report is available within the participant database. And for members of the public who wish to have this before them as a tool as they listen to the evidence throughout these hearings, this overview report will soon be available on the Commission's website. And Mr. Commissioner, I would ask that this overview report be marked as the next exhibit.
Okay, so that, Madam Registrar, will be Exhibit 3. Thank you very much. Okay, now we have 2 more reports, I believe, and it looks like we're going to be ending early today, something a bit of a bonus, which I don't expect we're going to have very often, but it was intended to be an overview day without any witnesses. That will start tomorrow. Alors, c'est fort possible et je dirais même inévitable.
So I think it's highly possible, even inevitable, that we will end earlier today.
Commissioner, as you note, the next 2 reports will not be marked as evidence, but they will be presented by Commission Counsel Etienne Lacombe to give context for some of the evidence that will follow. Those reports will deal with a primer on the Emergencies Act and a review of the Section 58 explanation provided by the government in relation to the Emergencies Act.
Okay, can I just before we hear from Mr. Lacombe, I assume these will be available to the public, and are we going to put them as exhibits or in another place on the website?
Well, they could be marked as lettered exhibits and in that term, or it could just be placed on the website. I think the best process would be to place them on the website and people can access them in that way.
Okay, so that's fine, and we'll advise the public how they can access it in due course then?
Yes.
Okay, thank you. Mr. Lacombe.
Monsieur le Commissaire, merci.
Commissioner, thank you. Hello, everyone. I'm Etienne Lacombe. I am Commission Counsel, and this afternoon I'm going to address the Emergencies Act. So what I want to do is to summarize the 2 steps. First, the conditions required to invoke this act and the measures that the government can take so if the Commission is providing you with this summary, is to present the evidence that you will be hearing over the next weeks. The role of the Commission is to assess the acts of the government according to the Emergencies Act. So I will go into some details, but it's going to be a summary. So I will paraphrase some of the measures, but I won't be able to give you all the details or all the exceptions. You will hear about that over the next few weeks while the Commission will continue its work. So, if in order to invoke this act, there needs to be a national crisis, a national emergency. The government needs to have reasonable grounds to believe that there is a national crisis, and there are various types of such crises. But all crises have some commonalities, but they're also different. So we'll start by defining the crisis to come to the particular emergency that the government addressed. So an emergency is an emergency situation which is temporary and critical, for which none other legislation in Canada is appropriate. And this, in such a case, the life, health or safety of Canadians must be threatened, and it must go beyond the ability to intervene of the provinces, and it should also threaten the ability of the Government of Canada to guarantee the sovereignty and the territorial integrity of the country. We're not just talking about something general, we're talking about 4 specific situations. We're talking about natural disasters, emergencies, international crises, or wars. So the conditions vary according to the type of emergency, and it's logical to focus on the type of emergency that was declared by the government under Part 2 of the Emergencies Act. I know that it's a lot of detail, so if you got lost on the way, don't worry. I will recap shortly, but in the meantime, in terms of emergencies, as you see on screen, it's a kind of emergency that is caused by threats to the security of Canada that constitute a national emergency. When we mention the security of Canada, we mean the 4 categories that are listed. So sabotage or espionage, foreign influence, terrorism, or violent extremism. And still about emergencies, before declaring an emergency, the federal government should customarily consult with provinces under Section 25 of the Emergencies Act. So recap, as promised, I want it to be as clear as possible, but what my takeaways are as follow. In order to declare an emergency, there needs to be a reasonable reason for the government to believe that a situation is urgent, temporary, and critical, that it stems from threats to the security of Canada, that it gravely threatens the health and security of Canadians, of the ability of the Canadian government to guarantee the sovereignty of Canada, that it cannot be addressed by the provinces and territories, and it cannot be addressed by using a different Canadian legislation. And so I talked about the criteria to trigger an emergency, and I will now talk about the measures that the government can use. So the government can when it has declared an emergency, adopt regulations or, for example, for public meetings or for movements. It can also establish rules for protected locations. It can order someone to provide essential services and can also have regulations on fines or on imprisonment. We will now briefly address the issue of federalism. The government can adopt measures under the Emergencies Act. It can adopt measures which would normally be under the jurisdiction of provinces. It should customarily consult with provinces. The government is not required to obtain the consent of provinces. And the last part that I would like to address are the protections under the Emergencies Act. So the government has temporary powers, but the Act also provides for some protections. The House of Commons and the Senate must vote to determine if it was justified to declare an emergency. The government must take orders in council and regulations publicly and clearly. It needs to set up a parliamentary committee where various members of the parties will sit. It can also revoke an emergency declaration, as well as the orders and the regulations at any point. And after an emergency, the government must table a report in Parliament. The powers that it uses must meet the criteria of the Canadian Charter of Rights and Freedoms. And there can also be a judicial review of the measures, that is a review by a judge. So what I was going to mention, some of you may know that the Emergencies Act replaced the War Measures Act. And just to give you the context, the War Measures Act did not include any of the safeguards that were mentioned on the previous slides or on this one. So this brings my presentation to a close. As you mentioned, Mr. Commissioner, these slides will be made available on the website of the Commission in both French and English for the members of the public and the parties who might want to refer to them in either official language. Thank you. So there is one presentation left, if I understood correctly. And maybe we can have it before lunch, and we would need to reconvene after lunch, if I understood correctly. Yes, it's still Mr. Lacombe. Okay, so it will save time. Go ahead.
And what I'm going to provide you is a summary of the reasons that the federal government gave in February 2022 for invoking the Emergencies Act. You've heard Ms. Chaudry earlier refer to this as a Section 58 explanation. That is how we'll be referring to it going forward, and the reasons for that will become clear momentarily. So a word about Section 58, Sub 1 of the Emergencies Act. It requires that Parliament review any declaration of emergency, that it be reviewed by the House of Commons and by the Senate. And for this review to occur, there has to be a motion to confirm the declaration that is laid before Parliament, ordinarily within 7 days. And the motion is accompanied by an explanation of why the emergency was declared. So that is the Section 58 explanation. So the federal government gave its explanation to the House of Commons on February 16th. It provided it to the Senate a few days later. That explanation is a document that is publicly available. The number that you see here in brackets is a reference for the parties to access that document within the party database. But the document is already publicly available on the federal government's website and will be made available through our own website as well. So it's important for me to pause here as Commission Counsel and to tell you that this is a summary of the explanation that the federal government gave. The reason the Commission is presenting it to you at this point is to contextualize the evidence that will be called in the coming weeks. So part of the Commission's mandate is to test and evaluate the explanation that the federal government has provided, and for that reason, it's important to know upfront what that explanation is. So this, again, just like in the previous presentation, is a summary. It's not a complete reproduction of the Section 58 explanation. And as I've mentioned, nor is it an endorsement by the Commission. It is a summary. Thank you. So the summary that the government provided sort of dovetails with the previous presentation that I just gave, in that it starts by explaining the necessary basis to invoke the Act, and for a public order emergency in particular, that there be threats to the security of Canada that are so serious as to be a national emergency. As I've mentioned previously, the threats to the security of Canada include threats or acts of serious violence against persons or property to achieve political or ideological objectives. National emergencies are urgent, temporary, and critical situations that seriously endanger the health and safety of Canadians that can't be dealt with effectively by the provinces or under any other law of Canada. So when it proclaimed an emergency in February 2022, the government identified 5 components of the emergency. You can see them on the screen here. We could loosely group them, or identify them rather, as the blockades and ongoing acts of violence, adverse effects on the Canadian economy, effects on Canada's relationship with its trading partners, effects on the distribution chain, and the potential for increases in levels of unrest and violence. And the way that the Section 58 is structured is by expanding on each of those 5 points that were in the initial proclamation. And that's how I'll run the next few minutes as well, by going through them one by one. So beginning with the blockades and the activities tied to serious acts of violence, the federal government explains in its explanation that there were various demands by protesters at the time, that they ranged from the end of public health measures to the overthrow of elective government. It also mentioned that there were different tactics being employed. There were those related to traffic disruptions, which we've heard about, and there were others, such as bringing children to protest sites to limit police intervention. At least this is what the government has said, and which I am summarizing. The government also said that there were issues for other governments and themselves in securing the assistance of tow truck drivers to remove vehicles from the blockades. It also mentioned violent incidents and threats of violence, including in particular the seizure of firearms and ammunition in Alberta. And finally, as regards blockades and serious acts of violence, the government also mentioned that there was online rhetoric, increased threats against public officials, and the presence of ideological extremists at protest sites, indicating a risk of serious violence. In terms of effects on the economy, the government explained at the time that the blockades were having severe impact on Canada's economy. It mentioned losses in terms of employee wages, reductions in automotive processing capacity, and other effects on the auto industry. It also mentioned breaches of the Canada Border Services Agency's plazas in 2 locations, that it anticipated additional blockades springing up, and that there was media reporting about the majority of donations being made through crowdfunding site Give, Send, Go, originating from donors outside of Canada. In terms of effects on relationships with trading partners, the government said at the time that there were expressions of concerns from various American voices, including from the President, from the Governor of Michigan, and from the Department of Homeland Security. It further stressed disruptions on supply chains and industry, and it said there was an erosion of trust or of confidence in Canada as a place to invest and to do business. In terms of the distribution chain in particular, the government at the time explained that that Canada's transportation system is particularly vulnerable given the challenges of geography and climate conditions in this country. It said that there was an imperilment of Canadians' welfare from disruptions in the transport of crucial goods, medical supplies, food, and fuel. And it also said that there were attempts by protesters in Ottawa in particular to impede access to the airport and to block railway lines. As for the potential of increased levels of unrest and violence, the federal government said, in addition to there being ongoing illegal activities, that there were concerns about ideologically motivated violent extremism, in particular, that the number of people who supported such ideologically motivated violent extremism could be increasing and could be a source of violence, that there were efforts by people based in the United States to enter Canada who were supporters of ideologically motivated violent extremism. It also mentioned the efficacy or inefficacy of current measures that were in place at the time, including injunctive relief and the ability of municipal and provincial authorities to enforce the law using the tools at their disposal. Finally, the government mentioned that the protests in Ottawa were impeding the proper functioning of the Government of Canada, including jeopardizing Canada's ability to fulfill its obligations with respect to the protection of the diplomatic community. So I'm at the point of conclusion here. What I'll stress again is that this is a summary of the conclusion that is in the Section 58 explanation. It's not the Commission's conclusion on the Section 58 explanation. And you can see from what's on the slide that it essentially tracks the meaning of what it would be required to have a public order emergency. It says that the situation in February 2022 was critical, urgent, and temporary, that the emergency arose from threats to the security of Canada, and that the measures that were used were necessary in order to supplement provincial and territorial authorities to address the situation. The explanation also concludes by saying that the measures were tailored such that any effects on the Charter of Rights and Freedoms were reasonable and proportionate. That's fine. So, Commissioner, that concludes the presentations of the day in its entirety, as I understand it. So I'll pass the floor back to you.
Okay, merci beaucoup. Thank you all. So we've run through quite quickly the
Thank you very much.
The opening statement, which I didn't labor too long on. And I think we can start tomorrow, 9:30, with the, I believe there's a series of panels tomorrow. Should be, I hope will be covered in without extending too late tomorrow. I hope will be another not too severe day, but we'll wait and see. There are, seeing no other issues being raised, I suggest we rise until tomorrow. Alors, on revient demain à 9h30 pour commencer la...
We will be back tomorrow at 9:30 for the evidence per se with panels that will begin presenting evidence in earnest, if I understand correctly, on what happened in Ottawa. Thank you all.
And that was Justice Paul Rouleau as he wrapped up this first day of the Public Order Emergency Commission. And you are watching CPAC as we bring you special coverage of this inquiry. Now, it is getting underway today, a 6-week process that will see dozens of witnesses be called to the commission. This is the much awaited inquiry into the Prime Minister's use of the Emergencies Act, an act that was introduced back in 1988. Never used until this past winter, truly a response to the trucker convoy protest turned occupation that lasted weeks on end in the nation's capital. Now, it was broken up by the RCMP once the Emergencies Act was enforced, and the inquiry that began today, is a requirement of the Act, because once invoked, a review must be undertaken, and that is what we are witnessing right now. We saw an introduction there from Justice Rouleau beginning the day off as he talked about the mandate and the purpose of this inquiry. And ultimately, the question here is whether or not the government was justified in invoking this act. Now, by calling the Emergencies Act, the RCMP was given greater jurisdiction in the capital that allowed them to move protesters away from the parliamentary precinct. There was also a suspension of some civil liberties, as banks were able to suspend bank accounts without going to the courts, as well as public assemblies were able to be broken up by the government, and in this case, the RCMP. So many questions here as to whether or not the PM was justified in invoking the act. Was the threshold met for the Emergencies Act, or was this government overreach? That is essentially what this commission will be looking at over the next few weeks. And of course, we've been giving you special coverage here on CPAC. We will continue to bring you special coverage throughout the commission's work itself. We will have special reports here on the TV station. We'll also live stream the full work of the commission on our website, cpac.ca. We'll also archive it for you so you have access to it whenever you want. But ahead of the commission beginning today, we did have a number of interviews speaking with some people who had some thoughts about the commission's work and the Emergencies Act and the protest turned occupation that happened in Ottawa last winter. Now, among the people we spoke to was freelance journalist, investigative journalist Justin Ling. Now, he has raised in the past the security concerns around not every protester, but some protesters who were helping organize what took place in Ottawa. Take a listen to freelance journalist Justin Ling, who we spoke to yesterday, about the security concerns that were raised not only by him as a journalist, but also security officials in this country. Justin Ling joins us now in Montreal. Justin, thanks for being here.
Thanks for having me.
Listen, as Justice Rouleau begins his work, I wanted to ask you to describe the protest, because there were those who came to speak out against mandates, whole families really who came out to support protesters who they saw being sympathetic to them being sick of government regulations. But there were also more radicalized elements that you reported on. What stood out for you about who came out or who stepped forward to organize all of this?
Yeah, so I mean, from the outset, my attention was paid primarily to those who actually organized this thing, right? The influencers, the activists, the organizers who actually put out the call for people to come to the city, who had spread misinformation, disinformation about vaccines and about the government, who have, in some cases, built little movements of people who have organized against the vaccines, against Justin Trudeau, against public health measures, in favor of conspiracy theories and quack remedies for COVID-19. And those people are several of the names that you hear all the time. People like Tamara Leach, people like Pat King, people like Chris Barber. Some of them we're going to hear from over the course of this commission. Some of them who have been a little bit less public-facing, people like James Bowder, people like someone we actually have heard from recently, Jeremy McKenzie, who organized some of the more radical elements that you mentioned. If you look at the organizers and the influencers, the people who actually put those calls out to the public, who actually got people to the Capitol, who actually did the logistics of pulling this crazy effort off, those type of people are folks who have a very paranoid view of how this country operates, who genuinely believe that there is a deep state cabal that is really pulling the strings, that the vaccines are not only deadly, but have racked up tens of thousands of deaths, that the government is covering it up. These are people who believe that the government is illegitimate, has not only broken Canadian law and the Canadian Constitution, but international war crimes laws in some cases. These are people who have written manifestos calling for the government to be removed. These are the people who I've been focusing on since the very beginning. Now, just briefly, there are a ton of people who came out, more than 10,000 people in that first weekend of the convoy arriving in Ottawa, and more than 1,000 of others who stayed for weeks on end. These people have a litany of different grievances. Some of them have been taken in by this misinformation, some of whom just oppose lockdowns and curfews, as many people in this country did and still do. Some of these people are well-intentioned but misled. Some of these people are radicalized. Some of these people do want to, for example, hang the prime minister and lock up the chief public health officers across the country. So there was a real mixed bag of people who came out to voice their support for this convoy and who enabled this ongoing occupation.
As you say, a mixed bag with certainly elements that you reported on that is concerning to security officials way even beyond the Canadian borders. But I think it's worthwhile to talk about the messaging here too, because more than 6 months later, people may have already forgotten. But there was a call to overthrow the Trudeau government by having the Senate and the Governor General dissolve Parliament to create a provisional government instead, where protest leaders would be named to that, governing council. Talk to us about that.
Yeah, so I mean, the foundational document of the so-called Freedom Convoy is a memorandum of understanding written by James Bowder through his group called Canada Unity. It was the document that propelled a previous convoy to Ottawa that never really took off. It is a document that was signed by hundreds of thousands of people. It was a document that was being shared around and spread around and pumped up by people who joined this convoy, including many of the organizers. It's a document that, like you said, basically purports to have the legal weight to remove the government, to call new elections, to install a new government or a new prime minister, to basically have the governor general and the Senate and this group, this Canada Unity organization, become a sort of junta for the country, right? A complete nonsense legalese. Now, there's a ton of people who are involved with the movement who say they wanted nothing to do with this memorandum of understanding, that it never spoke for them, that this was just one guy's idea. Again, it was signed by north of 100,000 people, but nevertheless, putting even that aside, which was clearly a misguided effort to sort of use a totally arcane legal mechanism that is totally nonsense to get their way. There were a number of people, I would say upwards of hundreds, if not into the thousands of people, who either on stage, on social media, on their signs, in chatting with journalists and other people at these occupations, voiced support for the idea that the prime minister, the whole government, health ministers, chief public health officers should be rounded up, should be put on trial, and should in some cases be jailed or executed. That was an idea that was unfortunately very common on the streets of Ottawa during those weeks. And of course, it was an idea that has percolated throughout. This very paranoid movement is an idea that has percolated throughout the anti-vaccine movement. In fact, people may already have forgotten, but there was an arrest made of a number of people in Coutts, Alberta, and charges were laid for them allegedly plotting to kill RCMP officers and potentially other members of representatives of the state. So I don't think we should ever discount the degree to which there was a belief that ran through this movement that the government is illegitimate because it pushed vaccines.
It's interesting that you mentioned Coutts, Alberta, because they did. They found a cache of weapons. They were charged with conspiracy to murder police. So I wonder then, because so much of the focus has been on the Ottawa police, how they failed to act or did not act strongly enough. But I'm wondering if overall, when it came to policing and who was meant to oversee and make sure this didn't become a security issue, where the disconnect was, where was there a failure of understanding?
I mean, it's such a difficult question because, the Ottawa police have always been very proud, and rightfully so, in their baseline that they want to let people protest, even if it's annoying, even if it's inconvenient, and they don't want to be the arbiter of what is and is not legitimate speech, within reason, of course. And I think at the outset of this convoy arriving in the city, they maintained the posture that this is disruptive, it is annoying, it is unpleasant, but it's their right to do so. And again, it's hard to say that they were wrong because we have to preserve a baseline in this country that people are allowed to come and voice their concerns, exercise their freedom of expression, even if it's over something that we all disagree with, right? And I think that has to be kind of the starting point for all of this. Now, taking all that into account, it's very clear to me, and I think to a lot of people, and I think it will become clear to this commission, that the Ottawa police do not only preserve and protect that freedom of expression, but also were lax in their attitude to the entire kind of logistical and security threat posed by this occupation. They should have known from the outset that the plan was not for just a weekend occupation, but for a longer stay in the capital right downtown. They should have geared up in terms of personnel and infrastructure to figure out how to manage the logistical challenge of all of these trucks. They should have never let these trucks occupy downtown Ottawa. While these folks absolutely have the right to come and be disruptive and annoying, they didn't necessarily have the right to use these massive rigs to do so. So there was a lot of points at which you can point to and say the Ottawa police were not prepared, did not have foresight, did not have the intelligence, did not have the forward planning. And I think we're going to learn a lot more about all of those particular points as this commission goes forward.
Okay, well, as we talk about this commission of inquiry, we're going to see and hear from the Prime Minister giving testimony, really to a same body that will also hear from protesters who are calling for Trudeau's overthrow. What do you think might come out of all of that?
I think it's the Prime Minister's, opportunity and obligation to finally kind of give us the full start to finish story of why the Emergency Act was invoked, all the steps that were taken short of that to try and manage this occupation, to underscore some of the security briefings he was getting about the possible threat posed by this group and other groups across the country, and to kind of fill us in on some of the both economic costs of all of this, but also the diplomatic and trade costs. Of course, we know the United States was quite incised over the blockages along various points of the border. So I think it's the first real opportunity we're going to have to hear him tell that whole story start to finish. That being said, I really hope the commission also focuses on the points at which he egged on, in some cases, this movement and this occupation. Because I think when the Conservative Party attacks him for doing so, they're quite right. I mean, he repeatedly insulted and belittled this movement in a way that was almost certainly not helpful and almost certainly harmful. And in many cases, I think actually exacerbated the situation, encouraged the sort of momentum behind this group, and fed into some of their victim narratives.
Okay, but the question at hand really for this commission of inquiry is to determine whether or not the invocation of the Emergencies Act was justified. And I appreciate you're not a legal expert here, but what comes to mind when you consider the question of legitimacy?
I think it's an incredibly good question. And frankly, it's been very frustrating to watch the conversation play out around the Emergencies Act, because a lot of the overheated rhetoric, I think, is really based on the sort of unfortunate relationship between this act and the War Measures Act, right? The War Measures Act was an inherently overbroad, ham-fisted, dangerous piece of legislation that amounted to a full frontal assault on the civil liberties of this country, especially when it was deployed by Trudeau's father. Now, the Emergencies Act was drawn and written up in such a way designed to curtail those risks and sort of encapsulate the Emergencies Act inside the Charter of Rights and Freedoms, which is a very, very good thing. Now, that should not be carte blanche to use it whenever a government feels inconvenienced or threatened, but it also does provide a constitutional and civil liberties protecting roadmap to invoking the act. And I think some people have attacked it as though it is still the sort of odious piece of legislation that preceded it. I really want to hear from the Prime Minister, from the government, from the ministers, from police, exactly how the act and the orders around it were written up, exactly how it was invoked. And I hope that in so doing, we can actually get an appreciation for the sort of red lines of when this act should and should not be invoked. Because we do, as a country, need a piece of legislation that can handle emergencies. We should not be afraid of invoking it. There should not be a big, only break in case of emergency box around it necessarily. But we also have to get an understanding for how it should be invoked, how it can be managed, and how it can be reviewed after the fact. And that's what this is all about.
Justin, really good to speak with you. Thank you for that.
Thanks for having me.
Now, Justin was mentioning he was looking forward to hearing from the Prime Minister to talk about why the act was invoked. And when we were listening to this first day at the inquiry, it was very clear as the timeline was set out by council lawyers that the government would not be speaking until the last 2 weeks of the commission's work. Now, again, this is a 6-week commission. Dozens of witnesses will be heard from. But in the final 2 weeks, we are expecting to hear, again, based on what we were told today, testimony from federal cabinet ministers as well as the Prime Minister, again, to talk about their justification, what information they had that led them to invoke the Emergencies Act. But in the days ahead, in this week, we are expecting to hear from local Ottawa residents, local government, and protesters themselves to explain why they were there, what they think of the act, and whether or not they believe it was an overreaction to what was happening on the ground. Now, to that, we also spoke yesterday with Keith Wilson, and Keith Wilson is one of the counsels for the protest organizers. He has already gone on record. He believes that the invocation of the act will go down in Canadian history as a disgrace. Take a listen to our conversation. Again, this is Keith Wilson. Keith Wilson joins us now. Mr. Wilson, thanks for being here.
Thank you for having me.
Now, this inquiry, it is looking into the invocation of the Emergencies Act, whether or not it was justified or an overreach on behalf of the government. And you've already stated, insinuated that it was an overreach. Why have you come to that conclusion?
Well, we're under law. We know that this is the successor to the War Measures Act. The legislation's only supposed to be invoked by cabinet when we're facing an extreme existential threat to the country, to the nation, to our, the enemy is within the border type of a situation. And what we know was happening when the Emergencies Act was invoked, when the cabinet decided to invoke it on the Sunday evening of the 13th of February, that weekend, the border blockades at Coutts and at Windsor had cleared. Those borders were all open. The only protest left in Canada at that time was the protest in downtown Ottawa. And over that weekend, myself as one of the lead counsel for the Freedom protesters had negotiated with them a deal with the Ottawa City Mayor to de-escalate the situation in Ottawa.
So a deal, as you said, between the organizers and the Ottawa Mayor. But really, what would that have done? How would that have ended the protest? Because my understanding of it, it was just about moving vehicles rather than vacating the parliamentary precinct.
Well, the main point of aggravation was the number of large trucks and protest vehicles in the downtown core. And, in the downtown area, of course, there's hotels and there's there's business towers, but there's also condo towers and there's apartments. And so the concern that some of the trucker leaders had was sort of overstaying the welcome, de-escalating tensions. And there you can see on the screen the trucks moving. So the arrangement that the mayor's vision was de-escalate the pressure on the downtown core, consolidate the trucks to the extent there was still space on Wellington, and then move the balance out of town to these remote locations that had been set at Armpar and another place. And then the truckers could shuttle in on buses, shuttle buses that were already in place, and attend protests during the day, but move the protest vehicles out of the downtown core to allow normalcy to come. And that was the vision that the mayor had. The trucker leadership agreed to it, and we were well on our way to implementing it on the Monday.
Well, the mayor of Ottawa is Jim Watson currently. He says he will not comment on the deal because he will be appearing before this inquiry. But there is a spokesperson for the public safety minister. And according to the spokesperson, cabinet did monitor actions after that deal was struck. And apparently they saw the deal being denounced by key organizers, which in part is why they moved forward with the Emergencies Act. How do you respond to that?
Well, it's going to be interesting to see what they have to say when they're under oath and cross-examined, because here's the facts. That there was strong buy-in from the truckers to make this move to de-escalate. The facts speak for themselves, which are on the Monday morning. After Sunday night, there was a logistics meeting at City Hall with one of the superintendents of police, the city manager, the head of emergency services, some of my legal team, and the trucker leadership. And they put a plan together that they implemented Monday morning. It resulted in 102 vehicles leaving the downtown, 42 of which were large trucks. 23 went up onto Wellington, as you can see on the screen, with police escort. And then the balance left town. We cleared 2 city blocks. We were on track to, the mayor agreed, and it's right in the letter that's publicly available and was filed in evidence, that the mayor recognized that this was a large logistical exercise and it could take 3 days to clear the downtown, but for Wellington. And that's what we were on track to do. We made great progress on the first day, cleared 2 blocks, and we were on track. And then we had problems on the Tuesday with miscommunication. There were so many different police agencies from Windsor and Kingston and different police forces. The communications between the police were really bad. And as we kept trying to move, we got blocked. And then on the Wednesday, I got a phone call from the city manager because we got blocked again as we were trying to do further moves. And he said that the new interim chief, as well as the federal government, didn't want the deal to go ahead, and it was stopped at that time. So they ended up bringing in police on the Friday and beating up and arresting Canadian protesters, clearing downtown by Sunday. If we hadn't had those interventions, we were on track to have the downtown opened up by the Wednesday earlier.
So the fact that there were 1 or 2 organizers on social media denouncing the deal is inconsequential?
Yeah, well, I mean, this was an organic event. There was, you know, when I was in the logistics center, the operations center, we'd get a report that 20 trucks were arriving, you know, from Kitchener, and then 30 trucks were arriving from Nova Scotia, and there was a convoy. Like, it was like, where, who, what? You know, this was not like an orchestrated event. It was purely spontaneous. And so the idea that there was some central command that could make everybody comply was just not how it worked in the real world. And it was all moral suasion. The buy-in was terrific. It was proven by the fact that the first 2 blocks that we attempted to clear were completely cleared out of all protest vehicles. Now, it is true that the vehicles were consolidating onto Wellington, but that's where the grievance was. The grievance was with the federal government and the COVID mandates. And, you know, interestingly, I just went for a walk. Wellington's closed right now. It's been closed ever since by the government. So with the barricades that they have up. So the reason that I and others believe this was an overreach, there wasn't a national security incident to begin with. The basic trigger to meet the law wasn't there. And what's troubling for me and others is that had there not been these interventions, we knew that the borders were open on the weekend. Well, all that was left was Ottawa. We had a deal working with the mayor and his vision to restore his downtown to the residents and businesses. And we were well on track to implementing that until it got stopped.
Well, respectfully, Mr. Wilson, there may be residents out there, many of Ottawa Centertown, businesses as well, people that lost money, lost their shifts, felt trapped in their home, that might argue that there was a security threat, a security to their person, not having the freedoms that they should be having because of this protest. What do you say to those individuals who may be more sympathetic to the use of the Emergencies Act?
Well, the crime data is empirical. Crime dropped. So that's going to come out. There's not even anybody suggesting that anymore. That narrative's gone.
But does that mean to say that individual residents were not harassed or felt trapped in their home?
Well, I'm not. I don't think they were harassed. That's not the prevailing thing, the evidence that I've seen and I observed my firsthand. But let's talk about something that's clear, which is they were inconvenienced. It wasn't a pleasant experience for some of the residents, for sure. In the same way that it wasn't a pleasant experience for Canadians to be facing mandates.
But these individual residents did not enact rules and regulations. They were just living their lives.
Fair enough, sir. But they chose to live in the capital city. And if you're going to suggest that the protesters should have gone to some remote rural community and protested there, when you live in the capital city and you enjoy the benefits of the incredible architecture and capital infrastructure that's here, we all know that protesters come here. This is not novel. You know well that the capital city of a country, of a nation, is where people go to protest when they feel their governments have crossed lines. That's what happened on a grand scale.
But I think though, the difference being that when there have been protests in the past, it might be a march to the Hill, it might be a protest on the Hill, certainly not an occupation that lasts day after day and into weeks. So very different, and certainly not protests that in the past have involved big rigs that are honking horns 24/7 and emitting carbon into the air that people are choking on. What do you say to that?
Never before in our history, sir, has a government, the federal government, invoked mandates that prevented 6 million unvaccinated Canadians from traveling by plane and train in their country, the second largest country in the world by landmass. Never before did thousands of people who worked at airports, baggage handlers, clerks, security people lose their jobs because they exercise their choice over bodily autonomy. I can keep going. Military, the number of people that have left our military that we invested in all their training because they were concerned about the uncertainty around the rushed approval of the vaccine. This was an incredibly, I know you're not going to suggest to me that the pandemic was a minor event, nor that the government's response was unprecedented. Unprecedented action by government will bring unprecedented response, I would suggest, by its citizens when they think the government's gone too far. And that's what happened in January and February in Ottawa.
Yeah, I think so, Mr. Wilson. I think, Mr. Wilson, and respectfully, I think the disconnect here, though, is that the people that ended up paying the price for that, in many ways during the course of this protest, were not actually the people enacting the laws, creating the regulations, but people who are just trying to live their lives, who are all of a sudden trapped in their home, and many of them not feeling safe to walk their own streets.
Well, Michael, I think that's why those who were trying to keep the protest peaceful urged the truckers that the time had come for them to move out of the downtown. And this is what civil disobedience is and lawful protests involves. It involves sometimes making government and people feel uncomfortable in response to the discomfort that the citizens felt by the government policy. So this is part of our democratic process, is that when people and citizens feel that a government's gone too far, is they engage in protest. And that's what happened. Was it of a grand scale? Yes. But it was spontaneous, and I think it was reflection of the depth of sentiment within Canadians that something had gone terribly wrong in our country, and the impact on their children with the school closures. Now, admittedly, the federal government didn't do that. But for those things that the federal government controlled, they felt they needed to come here and voice their concerns and ask for the rule of law and the charter to be respected.
So at the end of the day then, Mr. Wilson, what do you hope this inquiry flushes out?
Well, I hope the accurate information comes out, that we hear all perspectives. Really, the question for the inquiry is whether or not the freezing of bank accounts and the impact that had on people and isolating them, and how that could be done so arbitrarily, and preventing them from paying mortgages and getting gas and getting groceries and medicines for their kids. The level of violence that we saw from the police during the clearing out of protesters on the Friday, and to a lesser extent Saturday. Was that really justified? Why didn't the Prime Minister meet with the protesters and try and be proactive like Mayor Watson was in de-escalating the situation? I think those are questions that hopefully will get answered.
Keith Wilson, really appreciate the time today. Thank you for that.
Thank you, sir.
And again, Mr. Wilson is a lawyer who is serving as legal counsel for some of the protest organizers. Now, we do expect to hear more from him a little later this week. In the meantime, though, as we have been following the work of this commission, the first day of the inquiry into the invocation of the Emergencies Act, the Prime Minister is actually at a steel mill in Hamilton, Ontario. Now, he is there to promote his government's clean energy agenda. But during a news conference, he was asked about the inquiry taking place in Ottawa, getting underway today. Let's take a listen now to Justin Trudeau, how he answered the question regarding the inquiry, and the full news conference right here on CPAC.
First of all, this inquiry that starts today, 65 witnesses over 30 days, when it's all wrapped up, and the commissioner, if he finds that there was no justification for the federal government to invoke the Emergencies Act, should there be consequences for the federal government, including your resignation?
Well, we knew from the very beginning that invoking the Emergencies Act is a big step. It had never been done before. Given these unprecedented illegal protests, we needed to take action. We took it in a way that was measured, that was responsible, that was time limited, and we knew full well that there needed to be a public inquiry. Canadians need that level of transparency and accountability, and that's why we launched this inquiry. That's why I'm so happy to be, why I offered from the beginning to be part of appearing at this commission, and we're going to make sure that Canadians see the situation we were facing and how the tools we used were appropriate.
It's found that there was no justification for it. Again, what should the consequences be for that?
I think the important thing is for Canadians to understand the situation we were in and the choices we make. We didn't enter into using the Emergencies Act lightly. We used it with a sense of it was the necessary tool at the time. We used it in a way that was measured and proportionate, and we're really pleased that the Commission is going to be able to hear from all these witnesses, and that was why I offered to appear.
In Hamilton, we recently had a hate crime take place on the campaign trail, and it's people locally have already been pushing for Bill C-229, a private member's bill that would codify hate symbols like flags, and there was a Confederate flag flying at a house not too long ago that created a stir. And I just wonder, how much support does that bill have from you, and how, is that a priority for you? If so, how much?
We have demonstrated as a government how important it is to move forward with a full anti-racism strategy, to move forward to push back against this rise in intolerance we're seeing. Unfortunately, whether it's anti-Semitism, Islamophobia, anti-Black racism, anti-Asian racism, anti-LGBTQ rhetoric, there is a range of intolerance that is rising across the country, perhaps linked with the pandemic, perhaps linked with the rise in populism. We need to use all the tools we can to push back on it, and that's who Canadians are. We're a country that understands that differences can and must be a source of richness, of strength, and that's what we will always stand for.
So you support that bill, or?
We're going to continue to look at every way that makes a difference in moving forward to push back against racism and intolerance.
Prime Minister, Canada's ambassador to the U.S., Kirsten Hillman, says the U.S. cross-border nexus trusted travel program to be held hostage by U.S. effort to renegotiate this 20-year-old deal. Beyond strong words, what is your government doing to resolve the impasse? Ruling out any allowing U.S. protection offers to carry firearms?
We are engaging almost every day with our American counterparts to ensure the smooth flow of goods and services and people across our border. We have the longest shared border in the world that is extraordinarily important for both of our economies. We're going to continue to work with them on ways to make it smoother and more effective for people to work on both sides of the border. That's why the Trusted Traveler program like Nexus is so important, why we're so eager to get it rolling again.
Prime Minister, the ArriveCan app, this report today, the cost of the app is between $29 and $54 million to the federal government. Now, these companies in Toronto say they could have done it for $1 million, and this is gross overspending. How do you defend that kind of overspending?
Every step of the way, we put safety of Canadians first throughout the pandemic. We made sure that we were creating the tools rapidly in an unprecedented situation to keep Canadians safe. If we think back to the pressures and the challenges we were facing as a country, whether it was at the borders, whether it was on managing this pandemic here in your communities, we needed to use the tools we can. I can assure you that the current contract for ArriveCan was got at in a competitive process, and we're going to continue to be responsible in the way that we ensure the best possible protection for Canadians.
Next question is the last.
Alberta and Saskatchewan are both looking for ways to boost or protect their provincial powers. They point to Quebec as an example of how that would work. What do you say to premiers who believe you are wading into their jurisdiction too often?
My focus is what it has always been, on working with premiers across the country to deliver the best results for Canadians in their priorities, whether it's the rising cost of living, whether it's creating good jobs while we fight climate change, which is what we're seeing today, whether we work to keep our communities safe or push back against intolerance. I'm always there to work on the priorities that Albertans and Saskatchewanians and people right across the country are facing. We're there to work in partnership on the priorities of citizens across the country. We'll continue to do that.
The Prime Minister just speaking minutes ago in Hamilton, Ontario. And as you heard, when he was asked about the inquiry into the Emergencies Act, Trudeau says he looks forward to showing Canadians why it was appropriate to invoke the Act the first time in Canadian history. And when pushed, what he would do if the commission did not share his conclusion, well, the Prime Minister doubled down, basically said that the invocation was justified. Now, the Prime Minister, Justin Trudeau, is expected to appear before the commission, the inquiry into the invocation of the act. It is a 6-week process, and he will appear somewhere in the last 2 weeks of the commission's work. That is the timeline that we were provided earlier today. So we will hear more from the Prime Minister on the matter, and certainly we expect him to receive many questions in the weeks ahead as the commission continues to do its work. Now, as we talk about the inquiry, also to be heard before the commission is the legal counsel for local residents of the Ottawa Centretown community and local businesses. Now, that is expected to happen starting tomorrow and into the remainder of this week, talking about the impact that the protests and the occupation had on them. Paul Champ is the lead lawyer for the residents and the business association. We did speak to him yesterday about his expectations and what he hopes to come out of the inquiry. Mr. Champ, thanks for being here.
Thanks for having me, Michael.
Now, amongst the people speaking will be your client, Zexi Lee. She'll be appearing before the inquiry as she, for people who may have forgotten, is the Ottawa resident who sought and with your representation got an injunction against the blaring horns in the city's downtown core. What do you hope the inquiry gets from her?
Yeah, thanks, Michael. Miss Lee is going to be testifying about the experiences of downtown residents. There's going to be a few other witnesses who testify about that, but Miss Lee had not only her own personal experiences, but she was also trying to assist other people in her building who were more vulnerable, seniors who couldn't go outside and so forth. So she'll be talking about those experiences, as well as the serious harassment that she experienced once her name became known and associated with the horn injunction. So that will be her part in the inquiry.
How serious did the harassment get?
Well, the Ottawa Police and the RCMP were in regular contact with us. At one point her address was doxed, as they say, and there were some threats online. The Ottawa Police did a couple of times come to her apartment without us calling, like they came because of intelligence they were getting. So it definitely was a very unpleasant and scary experience for her.
And again, all related to the protest itself. Now, you also represent business and community associations from Ottawa Centretown area. Talk to us about how they were affected by the occupation, what you hope comes out of their testimony before the inquiry.
Yeah, well, I mean, I'm not sure how much people from across Canada understand about how profoundly impacted the residents and businesses and workers of downtown Ottawa were. Because of the trucks covering such a large area, it was almost impossible to get in and out of downtown Ottawa with vehicles. The trucks were idling all the time, so that the diesel fumes for anyone who had respiratory issues or didn't have respiratory issues were having breathing problems. And then the horns, the horns were absolutely deafening and were going on for several hours every day, early in the morning to late at night. Fireworks were going off in the middle of the night, like shooting off people's windows. There was gas cans and propane tanks everywhere, right beside open fires. And businesses had to shut down. The vast majority of businesses in downtown Ottawa shut down because they simply couldn't operate. They couldn't get their supplies in. Customers weren't coming, and to the extent they opened their doors, they would often be overrun with large numbers of the convoy protesters who refused to wear masks and became belligerent and aggressive if they were asked to wear masks. So, it was really a terrible time for the people of downtown Ottawa.
Mm-hmm. So businesses, associations, individual residents, all affected by this protest. And, earlier today, we were speaking with journalist Justin Ling, and he has reported extensively on some of the more troublesome elements of the protest, in particular, some of the organizers behind this protest. Do you have any concerns? Did you have any concerns about the individuals involved and descending in the Ottawa area?
Well, Michael, I think there was a real big mix of people who came to Ottawa for those protests. There's no doubt that, a lot of people in Canada, well, everyone in Canada were affected by the lockdowns and, caused a lot of distress to everyone. it was hard for everybody. And, some people unfortunately reacted in a different way and became very fearful for themselves and their families and were opposed to vaccines. And, people like that who were just opposed to the vaccines and the vaccine passports and issues like that, and they wanted to protest that. That was fine, but there was a lot of other elements for sure in those groups who I think, unfortunately, were maybe exploiting other people who were simply protesting because they were concerned about vaccine passports.
I want to pick up on that because, of course, here you are famously a human rights lawyer, as someone who has fought for the protection of civil liberties in this country. Did protesters go too far in their actions in trying to express their opinions?
Yeah, Michael, I'm a big believer in the Charter of Rights and Freedoms being like the defining values of Canada. And, freedom to protest, freedom of assembly, freedom of association are core fundamental freedoms in our country and in any democratic society. So, when these protesters first arrived in Ottawa, I fully supported their right to protest. There was going to be some inconvenience. There was going to be some interference with day-to-day lives.
through 2 years of a pandemic with serious sacrifices on behalf of many. And some of the folks who traveled across the country here were determined to make a point. And anytime they saw someone wearing a mask, that was, that person was seen as the enemy instead of a fellow Canadian. And that led to so many significant incidents of harassment. I also heard of many incidents of racism, folks who are not cisgendered like me, who are transgender, who are queer visibly, feeling like they couldn't walk safely to the gym, to their place of work in our community, particularly in Centertown. So I want to believe that most people who came here to protest against COVID policies, they didn't want to harass people. But the problem was the general feeling of chaos gave cover to people who have hate in their heart, who are targeting some of our neighbors. And what I hope comes out in the inquiry is some serious deep thinking about how we as a country can disagree on policies, but can never let that level of hate and dehumanization surface again, because I've seen it happen elsewhere in the world and it never goes to a good place.
Mm-hmm. As you know, the actions of Ottawa police have come under huge scrutiny as a result of what took place during the convoy protest. Could more aggressive action on the part of Ottawa police, do you think that might have mitigated what we saw?
Well, Michael, let's begin with maybe it was a bad idea to chaperone 500 vehicles into parking spots all over the downtown of Ottawa. I mean, who at the Ottawa police, who at senior levels of security in this country believed it was appropriate to let 500 vehicles permanently park and camp in the downtown core? Who believed, after everything we heard from the convoy leaders, that these folks were going to leave after a few days? That is just not a credible argument. So I'm looking at the inquiry into the use of the Emergencies Act. I'm looking at former Chief Slowly's comments. I'm looking at all security officials' comments. I'm looking at what the convoy organizers are going to say about what they intended to do and how long they were prepared to stay. So it was an abject failure from a security standpoint to let people be chaperoned into the downtown. Any responsible owner-operator of a truck should have had their license and insurance policies pulled by the province of Ontario within a week of something like this. I guarantee you, Michael, if someone was protesting against climate change, or someone was protesting against any number of other subjects, any vehicles involved would have been moved within hours of it starting. But there was an asterisk to this movement. And I want to understand through this federal inquiry into the use of the Emergencies Act, why was a double standard applied to this protest? And how can we make sure in the future, when debate gets heated in this country, that we can continue to see each other and not dehumanize each other, not throw each other under the bus?
Can I ask you, though, to define what that asterisk is? You say there's an asterisk attached to this protest. What do you fear it is?
Well, I've never known, Michael, of an occasion in the past, and I've attended many climate action events, for example. I've never known of any climate action events that have snarled the downtown for weeks on end, that our security forces were involved in donating to. But we now know that some members of the Ottawa Police Service donated to this cause late into it, when people had missed work, when people had been intimidated into the streets. We know that members of the Ottawa Police, and they've been brought up on internal charges, not only let it happen, but contributed to making it happen. So this is really, I think, a reckoning for us. We pay our municipal taxes as folks who live in cities to make sure that public safety is looked after, is guaranteed. And that did not happen in this instance. It took weeks for action to happen from any level of government. And I truly believe that if it was a protest over any other matter, this would have been solved in hours. For some reason, this was unworkable for our security expertise here. So I know what got us through, Michael, was citizens looking after each other. It was the legal injunction that stopped the honking that was going on at 80 decibels. It was the Battle of Billings Bridge, where people, including myself, peacefully blockaded convoy vehicles and told them they were not welcome in our downtown any longer. And then finally, the security establishment began to catch up to what citizens were demanding of our police forces. So my memory of, go ahead.
Sorry, and I'm quickly losing time, but I do want to ask you then, given all that you've just said, at the heart of this inquiry is whether or not it was proper to invoke the Emergencies Act, whether or not it was appropriate or an overreach. When you hear that question, what goes through your mind? Was it legitimate?
I lean to no. I lean to not suspending civil liberties. I lean to not having the kinds of extreme measures that the Emergency Act requires the state.
Jeez, if you're just tuning in,
if the province of
this guy
Ontario
is
had
completely
frankly
full of
acted
fucking
like the province
shit.
of Quebec did, we would not have had trucks parked here for weeks on end. In Quebec, they threatened to pull
Unbelievable.
licenses, they threatened to pull insurance policies, and the trucks rolled into Montreal and Quebec City and left. But in Ottawa, the province of Ontario, Premier Ford, did not use those powers. And I'm shocked at the fact that there's really, from my understanding, only one party, the Deputy Solicitor General from Ontario, participating in this inquiry, because frankly, Ontario has a lot of questions it needs to answer. Because this won't be the first time we have a major security event. There will be others. So how do we make sure we can protest vigorously if necessary, but also not dehumanize or harass neighbors who may have a different view?
Joel Harden, thank you for the time today.
It's my pleasure, Michael. Be well.
And again, Joel Harden is an area resident of Ottawa Centre, the neighborhood, the epicenter of the protest last winter. He's also the Ontario Member of Parliament for the riding of Ottawa Centre. So clearly, as we heard from Mr. Harden, he does not support the invocation of the Emergencies Act. But Michael Kempa, who is a security expert, does agree with the invocation, at least given the circumstances with which Ottawa was dealing with at the time. Take a listen to what we heard from Michael Kempa, not only a security expert, but also a professor, part of the criminology department at the University of Ottawa. Take a listen to our conversation and his thoughts on the Emergencies Act. Michael Kempa is a professor of criminology at the University of Ottawa. He joins us right now. Michael, good to see you again.
Thank you. Thank you.
Now, you have been very clear in the past, you believe, or believed at least, that the government was justified in using the Emergencies Act. Why is that?
Well, it's very regrettable that it was necessary to mobilize the Emergencies Act. It was simply the case, though, that the normal chain of civil institutions, from municipal policing up through municipal government, provincial government, the federal security agencies, had not managed to bring the crisis under control. There were really no options left other than to mobilize the Emergencies Act, even though it should probably have never have gotten to that had our agencies been prepared in advance.
Had they been prepared? Now, was it just a matter, though, of giving them more time to respond rather than invoking the act?
It wasn't a question of time to respond. Peter Slowly, the former chief of the Ottawa Police Service, gave very clear evidence on this last week to the Special Joint Committee in Parliament and the Senate on this matter, where he said most of the structural issues in our police organizations, in our different levels of government, we're simply not prepared for this magnitude of protest or crisis. And most of these structural issues have still not been repaired to this day. So it wasn't a matter of time in that moment. It was more a matter of really making sure that our police organizations are organized for this type of protest. Our security organizations are asking the right questions and gathering the right information, and that we are prepared moving forward, having had to invoke the Emergencies Act once.
Okay, well, let's go back then. If the structures were insufficient, if the right questions were not being asked, why those deficiencies? Why weren't they better prepared? Was this just something that Canada has never seen before?
Canada's not seen it before. Our security agencies have not been focused on domestic, ideological, violent extremist groups, both on the far left and the far right. We had been focused on terror issues external to Canada, most especially a preoccupation with what was known as Islamist terrorism, which is different from the Islamic faith, obviously. This type of grassroots violent political extremism, though, has been a problem in Canada for at least a decade, and a growing problem, and our agencies were simply not focused upon it. And when we saw it approaching last January and February and bedding down in Ottawa, at the borders across Canada, and especially in Coutts, Alberta, with the discovery of weapons, we were surprised by what we saw simply because we had not imagined that it was this degree of a problem in our own country.
Now, I think there's a disconnect, though, because, of course, people will see the coverage. They will hear security experts like yourself talk about the concerns around national security, the type of danger that was present. But for many protesters, those who came out to support protesters, they still will argue that they have a right to demonstrate. And for them, it was a pushback on vaccine mandates because that's what they came out for. It wasn't for any other reason, political or otherwise. What would you say to that?
Well, people certainly do have a right to protest and freedom of expression in Canada. There were layers to this protest. There were very many thousands of people who came out to protest vaccine mandates. The problem that we have, though, is that protest and the freedom of movement of individuals does not extend to heavy machinery and trucks and blocking public roadways and preventing essentially cities from being able to do any of their business and citizens to go about their daily essentials. So we don't have an unlimited right to free movement. The police are allowed to control the flow of traffic in our society, to make sure that emergency vehicles are able to get through and that citizens can access essential services like pharmacies and doctors and so forth. One of the issues we have had, though, is we don't have clear legislation in Canada that draws the distinction between where protest is legal and where it breaks down. In other places, in the United Kingdom, they do have this legislation. It's very clear. And it does not set undue limits on people's ability to freely express their opinions or to move around in nonviolent protest.
Okay, so what are the limits? If you're pointing to the United Kingdom as an example, what limits does the UK have that Canada does not have on the freedom of assembly and to protest?
Well, the UK legislation is very clear on not using heavy machinery or other objects to block public thoroughfares, public roadways. They're very clear on not having weapons of convenience. So things like flagpoles and whatnot that can be quickly broken down to use as weapons in crowds. They're clearer on the limits of hate speech and speech which incites violence. We do have limits in Canada, but they are a little bit clearer in the United Kingdom. They are things that allow police to act with more confidence in breaking up protest when it does begin to cross the line into illegality, while not interfering with legal protest.
Okay, but you know, when you look at the charges that have come out of this action, they actually have nothing to do with violations of security. Instead, what we're looking at are mischief charges, nuisance charges. How do those crimes meet, or rather merit, the invocation of an Emergencies Act if, again, none of the charges laid have anything to do with security?
This is an essential question for the inquiry. And the tricky business for the public watching is simply that when you invoke the Emergencies Act, it enables the government to go into the law books to select certain tools to ramp up for a period of time. So in our case, we said this time certain areas were no-go protest zones. If you were participating in those zones or donating money to what was going on in those zones, you could have your accounts frozen and so forth. These were extraordinary powers that were basically designed to break up the crowd. When we're talking about laying charges, very often, even in a situation of emergency, Crown prosecutors and police will simply pursue the simplest charges that can be laid and taken up in the courts. So things like mischief, obstructing police officers, or assaulting police officers, these are straightforward charges that are easily prosecuted through our courts that do not require very complicated trials with very difficult standards of evidence. So the idea would be the Emergencies Act was for breaking up the crowd, but then in a sense, there's no reason to crush a butterfly on the wheel. Once you have people dispersed and you've only charged a small number of people, it's very often not necessary to use the most draconian laws for criminal prosecution. You can proceed with very simple charges that do not have enormous jail times associated with them, partially for the reason that you don't want to come down too heavily on people that may have a significant amount of public sympathy if you were to unnecessarily use huge laws against them in the courts.
But does that not undermine the justification for using the act in the first place?
In a sense, it does. If there had been sufficient police officers in Ottawa with an adequate plan and procedures and policies in place to deal with a major protest such as what we saw in Ottawa, the enforcement of all of these conventional minor criminal offenses, mischief, damage to property, any forms of violence, open liquor, violation of moving violations for traffic in the city. It could have been broken up. The key being that these things were not in place. We did not have sufficient officers. We all saw OPS seeming to be hanging back, the auto police seeming to be hanging back for the justification that they said they would have been swarmed had they enforced many of these things. It got to the point where ordinary laws could not be used to break down up the crowd, and that's where the invocation of the Emergencies Act came into play. If we're ready next time, it should never again get to the point that the Emergencies Act would need to be mobilized for dealing with a protest of Canadian citizens in domestic territory.
Now, dozens of witnesses will be heard from in the weeks ahead. Is there any one or any group of particular witnesses that you're looking forward to hearing from?
They're all essential who are on the list. There was a bit of a debate. Should the organizers of the Freedom Convoy be given the platform to present their views in the inquiry? Absolutely, they should. Canadians need to hear what is their side of the argument. What evidence have they got to support their claims that they were only here for a peaceable protest to do with COVID-19? They must answer questions to do with which streams of organization were tied to events in Coutts, Alberta. Was there coordination between the protests in Ottawa and the blockades of the essential crossings into the United States? Canadians must see and hear the evidence that these groups have and judge it for themselves.
Michael, really appreciate your thoughts once again. Thank you for the time today.
Thank you kindly.
So, as you clearly heard from Michael Kempa, he believes the invocation was appropriate given the situation at the time. But the Canadian Civil Liberties Association does not agree. In fact, 3 days after the Emergencies Act was triggered, the association announced it would be taking the government to court. And Canadian Civil Liberties does have standing before the inquiry. CPAC's Andrew Thompson is at the Canadian Library and Archives building where the commission is doing its work. And he had a chance to speak with the CCLA's Kara Zwiebel.
Kara Zwiebel is with the Canadian Civil Liberties Association. Thanks so much for joining me.
Thanks for having me.
And we're getting this commission started now. And this morning you made the point again, and it's a point you've made over the past several months, that the threshold was not met for the Emergencies Act declaration several months ago. What are the key questions then that you're hoping comes out of this inquiry, and especially this phase we're going to be hearing from witnesses now over the next several weeks?
So, I mean, I think we want to hear, what evidence the government is relying on to support their view that there was this serious threat to national security or a serious threat to the lives, health, and safety of Canadians. There's no doubt that there was a crisis situation. The question is whether it rose to that level that's set out under the Emergencies Act. And we haven't, heard evidence from the government that we think supports that view. I think some of the other things we want to understand have to do with how information was shared among the various levels of government and the various police services that are involved, and did that system work effectively in making sure everyone knew what they needed to know and could take steps and cooperate to address the circumstances on the ground.
So looking at the witness list then over the next several weeks, are you concerned that we're hearing from enough voices, that we're hearing from a wide enough array of the people who were involved in it? Certainly we are going to, in theory, be hearing from the Prime Minister at the end of these hearings, but just your thoughts on the overall scope of people that we're going to be hearing from.
Yeah, I think I think there are concerns about some potentially missing voices. Again, there's the hearings that will involve witnesses coming in person to give evidence. There are other ways that the commission is going to be putting evidence in. So we need to see exactly what some of those things will look like. But in particular, there aren't a lot of people that are representatives of provincial governments on the witness list. And so there may be some information missing there about the relationships and the communication between the federal level of government and provincial governments.
And we've also been told to expect thousands of documents over the next several weeks, including the decision by the government to, what they say, they're going to waive cabinet confidence for many of these documents. Now, we know yesterday here in Ottawa, you expressed some concern about that. What are your concerns about the public actually being able to see these documents, to see what was actually informing the government as they work towards making that declaration?
Yeah, so I think I think that my understanding, I guess, at this stage is that cabinet confidence has been waived in terms of sharing information with the commission. And what I don't know yet is whether that extends to sharing information with the parties and potentially with the public in terms of introducing some of that evidence over the course of the hearings and getting those documents, before the public. So I think we need to see exactly what that process involves. There's also, we know that there are going to be some claims around national security privilege, and the commission has already indicated that they anticipate a short in-camera proceeding involving witnesses from CSIS. So, we need to understand sort of what the commission will see versus what the parties will see, and how that information gets communicated to the public.
All right, and finally, I want to just talk to you about the overall timeline. It was one of the first things we heard Justice Rouleau talk about this morning in comparing this inquiry to some other high-profile commissions that took several years. He's had 300 days, essentially, from the time the commission was called until he has to report. What concerns do you have about the timeline for actually going through all this information and for the commissioner to be able to reach conclusions?
Yeah, I think it's a huge challenge. I mean, I think that it sounds like everyone involved in working for the commission has been working, 24/7 to try and get to get things in shape to get to this point, and will continue to have to do so to get things across the finish line by February of 2023. At the same time, I think that there is a benefit to not allowing something like this to drag on for several years. I mean, the benefit, the one main benefit of getting a report by next February is that we will have something with findings of fact and with recommendations that is relatively close in time to the events. Not a few years down the road when maybe people have sort of forgotten about how significant this was. So there are benefits to doing things quickly, but we obviously don't want the quality to suffer. And I think everyone that's involved in working with the commission has been trying very hard to make sure that's not the case.
All right, we'll certainly be watching over the next few weeks. Kara Zwiebel, thank you so much for your time.
Thank you.
And again, our Andrew Thompson speaking with Kara Zwiebel of the Canadian Civil Liberties Association. I'm Michael Serapio, and you're watching special programming here on CPAC as we cover the inquiry looking into the invocation of the Emergencies Act. Now, officially known as the Public Order Emergencies Commission, the inquiry got underway today, and it will work for the next 6 weeks. Dozens of witnesses will appear in that time, including the Prime Minister and protest organizers. And by the end of it all, the commission will need to determine whether it was appropriate of the Trudeau government to invoke the act and curtail civil liberties to address the convoy protests and occupation in Ottawa. Now, we will have extensive coverage for you in the weeks and the days ahead here on CPAC. We'll also stream for you and archive the full work of the commission on our website, cpac.ca, so you can access it at any time. But for now, we are going to bring you the other stories of the day in just a few minutes' time. But we want to leave you right now, with the opening statement from the inquiry's commissioner, Justice Paul Rouleau. This was delivered 9:30 a.m. Eastern Time today, as he talked about the mandate and the work of the commission in the days ahead.
In these opening remarks, I want to address the following: the role of public inquiries, the mandate of this commission, the challenges facing the commission, how the commission has carried out its work to date, what to expect from these hearings, the participants of the inquiry, the importance of openness and transparency, and finally, the policy phase of the commission. Le rôle des commissions d'enquête. Pour bon nombre de personnes,
the role of public inquiries. For many, this will be the first inquiry that they attend, view, or indeed follow. As such, I would like to say a few words about what commissions of inquiry are and what they do. A commission of inquiry is an independent body appointed by a government with the mission to investigate matters of public importance. Commissions are headed by one or more commissioners who have the overall responsibility for the work of the commission and the ultimate duty to report on the subject matter of the inquiry. Commissioners are assisted by lawyers, administrative and technical support staff, frequently supplemented by subject matter experts, researchers, investigators, and other specialized roles. Commissions of inquiry are often called public inquiries. That is because commissions work to be transparent and open. Hearings are normally conducted in public, and anyone is entitled to observe, as one can see today.
Recommendations for the future. The fact-finding role of commissions of inquiry serves an important social purpose. To borrow the words of Peter Corey, who was then a judge of the Supreme Court of Canada, and I quote, "One of the primary functions of public inquiries is fact-finding. They are often convened in the wake of public shock, horror, disillusionment, or skepticism in order to uncover the truth." End of quote. Uncovering the truth is an important goal. When difficult events occur that impact the lives of Canadians, the public has a right to know what has happened. But inquiries are also forward-looking. They seek not only to understand what has occurred in the past, but also to learn from those experiences and to make recommendations for the future. A commission's recommendations may be modest or wide-ranging. They may be directed at a range of audiences, including government, public bodies, and the private sector. It's also important to understand what commissions of inquiry do not do. They do not make findings of legal liability. They do not determine whether individuals have committed crimes. While inquiries seek to uncover the truth, they are not trials. Questions of civil and criminal liability are decided by courts and not commissions. Turn now to the mandate of the commission. Like other commissions of inquiry, the Public Order Emergency Commission has been given the mandate to seek out the truth about an important event. However, unlike other commissions of inquiry, we have two mandates. One given to us by Parliament and one given to us by Cabinet. Le mandat confié à la Commission par
The mandate given to the Commission by Parliament is found in the Emergencies Act itself. When Parliament passed that law in 1988, it chose to include in it an important rule. If the government proclaims an emergency, it must also create a public inquiry to examine, and I quote, "the circumstances that led to the declaration being issued and the measures taken for dealing with the emergency," end quote.
One of public accountability. The public's legitimate right to know why the government proclaimed an emergency and whether the actions it took were appropriate. When Cabinet took the step of establishing this commission, as it was required to do, it set out an additional mandate. Our order in council directs the commission to examine, first, the evolution and goals of the convoy movement and border protests and their leadership, organization, and participants. Second, the impact of domestic and foreign funding, including crowdsourcing platforms. Third, the impact, role, and sources of misinformation and disinformation, including social media. Fourth, the economic and other impacts of blockades. And finally, the efforts of police and other responders prior to and after the declaration. There is, however, an important caveat to this mandate from Cabinet. The Commission is asked to examine these issues, and I quote, to the extent relevant to the circumstances of the declaration and measures taken, end of quote. In other words, although these topics have been identified as worthy of attention, it is the mandate that has been given to us by Parliament that drives the Commission's work. While this inquiry will deal with a wide range of issues, its focus will remain squarely on the decision of the federal government. Why did it declare an emergency? How did it use its powers? And were those actions appropriate? This commission exists to promote transparency, accountability, and public confidence. I hope that this inquiry and the transparency we strive to provide will bolster the public's trust in our systems of accountability. Now, the challenges facing the commission. Discharging my mandate is not an easy task. The commission has faced many challenges in reaching this point and will face further challenges as the inquiry proceeds. The biggest challenge has been time. This commission of inquiry is unique, to the best of my knowledge, or our knowledge, is in that its deadline is set by statute. Other inquiries have worked under deadlines set by cabinet. That sort of deadline is set based on an assessment of the time needed and can and frequently is extended as circumstances require. This is not a possibility for our commission in the absence of a change in the Emergency Act itself. Our deadline is established by statute, as I've said. It is a short one, and it allows by statute for no extensions. Just how tight are the timelines? Let me try and put it in context for you. The Air India inquiry was established on May 1st, 2006. It took just over 4 years to issue its report on June 17th, 2010. The Commission on the Decline of Sockeye Salmon was established on November 5th, 2009, and its report was made 3 years later on October 31st, 2012. The inquiry into missing and murdered Indigenous women and girls was established in September 2016 and issued its report almost 3 years later on June 3rd, 2019. This commission, on the other hand, was established in April and must table its report in Parliament on February 20th, trying to give myself 3 days, on February 20th, 2023. So it has only 300 days. So it's measured in days, not years, to complete its work. Ces contraintes de temps extraordinaires ne sont pas le seul.
These extraordinary time pressures are not the only challenge that the Commission has faced. Access to relevant documents has also been a challenge. The federal government has expended significant effort to produce to the Commission materials from a dozen departments and agencies, yet the process has been slow and complex. Documents continued to be produced to the Commission into October, up to today, in fact. This weekend, we received some as recently as that. Many of the documents given to the Commission are classified, subject to national security or other privilege claims. This limits how the Commission can handle these materials, as well as how they can be used and shared. So beyond the federal government, the Commission developed a process so that the public has relevant access to these documents. And beyond the federal government, the Commission received more than 50,000 documents from provincial governments, police corps, municipalities, non-governmental organizations, industry groups, and private entities. All of the materials received had to be carefully assessed for relevance and privilege, analyzed by Commission counsel, and where appropriate, disclosed to the parties for the purposes of their own review.
Has been challenging. These public hearings will no doubt present all parties with new challenges. Commission staff and parties alike have had to be flexible, innovative, and creative in their approach to their work. These hearings will need to be conducted in a manner that will allow the Commission to fulfill its mandate within the timelines that it has been given. They also need to be fair and meaningful, guided by the principles of openness, timeliness, and proportionality. I intend to ensure that they are. Now, how the Commission has carried out its work. I want to give the public a little more detail about the work that the Commission staff have done over the past 4 months to conduct their investigation and prepare for these hearings. Shortly after being appointed, I set about selecting and retaining a senior staff and retained the services of Commission counsel. I then, in consultation with counsel, guided the work of the Commission. Several investigative dossiers were identified, and each was headed by a senior Commission counsel. Additional counsel were hired in the weeks and months that followed to assist these investigations. In order to ensure that the various parallel investigations did not exist in silos, junior counsel were appointed to multiple dossiers. And all the Commission counsel would meet weekly to keep each other apprised of the status of their work and keep the network working together. Now, this requirement to pursue the investigation in a number of parallel streams explains why you'll see several different Commission counsel leading evidence in the course of the hearings. Now, counsel worked to identify, request, and obtain relevant documents that were in the possession of parties to this inquiry, as well as non-parties. In the case of the federal government, this process involved addressing the government's assertion of cabinet confidence, which resulted in the government agreeing to a significant disclosure of information otherwise covered by cabinet confidence. As I understand it, this is only the 4th time since Confederation that Federal Commission of Inquiry has been granted access to cabinet confidences. À mesure que les documents ont été obtenus et analysés, les avocats principaux ont...
As documents were obtained and analyzed, senior counsel began to conduct interviews with key witnesses. These interviews took a variety of forms, from short telephone calls to full-day meetings with panels of senior government officials. Protesters and cabinet ministers alike were interviewed by the Commission. Recognizing that hearing time would be limited, Commission staff also requested and obtained institutional reports from a variety of entities, including federal departments and agencies and provincial governments, as well as municipal governments, police corps, and private entities. These reports summarize the information available to these entities and describe their involvement in the events surrounding the declaration of a public order emergency. And they will, where appropriate, be filed at the hearing as part of the evidentiary record.
During these public hearings, Commission counsel have analyzed the information available to them and prepared evidence to be presented in a number of different ways. They've prepared summaries of the interviews that they conducted, and to ensure fairness, the interviewees have been given the opportunity to review these summaries and approve them as accurate. The interview summaries have been shared with the parties to ensure that they are aware of the information obtained by the Commission. In some instances, these summaries may be introduced to supplement and facilitate the oral testimony of interviewees. In other circumstances, the summaries may simply be entered into evidence where it may be unnecessary or impractical to hear from the interviewee in person. Commission Counsel have also prepared a series of oversee reports. They summarize large amounts of evidence related to a particular issue. They have also worked to prepare lists of witnesses who will provide live testimony in these hearings. Enfin, les avocats ont examiné la grande quantité de documents reçus afin de déterminer les...
Finally, Commission Counsel have reviewed the vast number of documents received in order to identify those pertinent to the issues before the Commission, which have been shared with the parties. And this is done on an ongoing basis. In the case of documents received from the federal government, this process involved assessing the government's assertions of national security and public interest privilege, and working to make as much information as possible open to the public. Throughout all of this work, the Commission's staff have undertaken countless additional duties, from locating hearing space for the inquiry to drafting the rules of procedure to working with translators and editors to ensure that the final report can be produced on time.
Investigative work that I have just described has been that of Commission Counsel. During these hearings, I will be hearing the bulk of this evidence for the first time, just like members of the public. To that end, I've made no findings and reached no conclusions about the issues that I have been entrusted to deal with. While I'm not sitting as a judge in these hearings, my 20 years of experience as a judge have informed my approach to the inquiry. I intend to take a judicial attitude to my job. By that, I mean that independence, impartiality, and fairness are my touchstones as commissioner, just as they are in my role as a judge, which I will take up again after these hearings. Like a judge, my findings and conclusions will be based on the evidence that is presented to me. I will keep an open mind throughout and will only reach a final conclusion once the evidence is all in and final submissions have been made. Now, what to expect in the hearings? We have scheduled approximately 30 days of factual hearings. At first glance, that may seem like a great deal of time. In reality, our time is very limited, given the breadth of the issues that have to be covered. This commission will need to hear from dozens of witnesses and examine thousands of documents. Our timelines are tight, and there's little room for error. For these hearings to be successful, I'm relying not only on my commission counsel, but on the efforts of all counsel appearing before me and the parties they represent. This is not a trial, it's an inquiry, and I expect everyone will work cooperatively to ensure that the facts and information necessary for the public to understand what happened and why it happened will be elicited. I appreciate the spirit of cooperation that the parties and their counsel have demonstrated thus far, and I expect it to continue. While this is not an adversarial proceeding, I recognize that different points of view will be forcefully advanced. This is to be expected and will help ensure that a clear picture of the events is presented and the decisions made or not made by key actors are fully analyzed. It is important, however, that at all times disagreement be respectful. Parties and the public should also expect me to actively control the proceedings. Deadlines and time limits will be established and enforced. Parties will be required to focus on central issues. Not every witness who might be called will be called. Relevant evidence may be adduced in writing. Objections and procedural wrangling must and will be kept to an absolute minimum. Throughout this process, I will be relying on Commission counsel to take the lead in presenting the evidence. For members of the public who have not seen a public inquiry before, the role of Commission counsel may appear a bit unusual. They do not represent a party. They are, in effect, an extension of the Commissioner. They do not advance any particular point of view, but rather they lead evidence in an impartial and balanced manner. Their only goal in these proceedings is to elicit the evidence necessary to establish the truth, whatever the evidence may be. Now, other participants, Commission counsel, are not the only persons who will play a role in these hearings. There are also some 20 parties to whom I've granted permission to participate in these hearings in a variety of ways. This includes the Government of Canada, as well as provincial and municipal governments, police forces, protester representatives, community organizations, non-governmental organizations, trade associations, and individuals. Each has their own interest in the issues that will be addressed in this inquiry, and each brings their own important perspective. They too will play an important role in the process. Afin de permettre la participation,
in order to permit individuals and groups who might otherwise not have been able to participate in these proceedings, I made recommendations to the clerk of the Privy Council to provide funding to certain parties with standing. I outlined my reasons for doing so in a series of decisions that are available on the Commission's website. While I did not have the authority to award funding, the clerk of the Privy Council accepted my recommendations. Aside from the parties, this commission has also benefited from the participation of the public. From the outset of my appointment, it was clear to me that I needed to obtain input from Canadians from all walks of life on their views and experiences related to all aspects of my mandate. It was for this reason that the Commission established an accessible online method for members of the public to share with us their views, observations, and ideas on the circumstances that led to the declaration of an emergency and the measures taken by the government in response.
Individuals expressing a range of views, opinions, beliefs, and ideas, and we look forward to continuing to receive submissions as these hearings unfold. Commission staff will carefully review all submissions and will prepare a report on the public input received, and this will be shared with you. To the members of the public who took time and effort to share your insights with the Commission, I thank you. The inquiry has benefited from your contributions, and I will be mindful of the views expressed as I continue my work. Now, openness and transparency. The role of a public inquiry under the Emergencies Act is very much about serving the public. Maintaining public confidence in our public institutions and holding government to account can only be achieved through a process that is committed to openness and transparency. To that end, the Commission has worked hard to make these proceedings as accessible as possible. The hearings themselves are open to the public to come and observe. The media has been invited to broadcast our proceeding, and anyone around the world, in fact, is able to watch or listen to the hearings on the Commission's website. Transcripts of proceedings will be produced and made available for download. I've already said that much of the evidence in this proceeding will be adduced in writing. The Commission also intends to post all documents that are made exhibits to the Commission's website so that the media and the public will be able to read and understand all of the evidence before me. We expect that thousands of pages of material will ultimately be posted. Enfin, comme il s'agit d'une enquête.
Finally, as a national inquiry, we are committed to ensuring that our proceedings are accessible to the public in both official languages. Witnesses may testify in either English or French, and all proceedings will be simultaneously translated. Documents prepared by or on behalf of the Commission will be translated and made available in both official languages on the Commission's website. Where possible, both language versions are released simultaneously.
Limits on the Commission's ability to be fully open to the public. Much of the material reviewed by Commission counsel during their investigation is classified or subject to public interest immunity or national security privilege. As a result, there may be short portions of the hearing where classified evidence will be presented to me, which cannot be open to the public or the parties. We will strive to keep such hearings to an absolute minimum. The policy phase. I have already spoken about how this Commission will not only look to the past, but also to the future. The Commission's mandate includes a direction to make recommendations for potential changes to laws or practices relevant to the matters before this Commission. Pour soutenir ce volet des...
To support this branch of the Commission's work, we have also had an ambitious research and policy program in place for the last several months. To assist the Commission, a research council comprised of academics from across Canada was assembled. Chaired by Professor Geneviève Cartier, the Research Council has worked tirelessly to commission research papers, brief Commission staff on technical matters, and shape the overall policy direction of the Commission.
Work is already available to the public for viewing. A series of 14 research papers on topics relevant to the Commission have been posted in both official languages to the Commission's website. After the factual phase of the inquiry is complete, the Commission will be holding a series of policy hearings to further explore the broader issues relevant to the Commission's mandate. This will include policy roundtables involving experts and stakeholders who will present their views to the Commission so that I may be better equipped to make recommendations about the future. Now, in conclusion, this Commission is about to begin the process of finding answers to the questions assigned to it by Parliament. What led the federal government to declare an emergency? How did it exercise the powers that it obtained? And were its actions appropriate? These are matters of fundamental importance. Ce sont aussi des questions.
These issues are also very complex, and I will hear a lot of witnesses within very short time frames. It will be a challenge, but I am confident that with the cooperation of all parties, the hearings will provide a fair and thorough process for the presentation of the evidence required for this Commission to be able to give the public the answers to which it is entitled.
Of the exceptional powers given to it by the Emergencies Act affects directly or indirectly all Canadians. In the 34 years since its adoption, This is the first time the Act has been used, and this is the first time opportunity for its review. How and why the powers in the Act were invoked are matters of great public interest. With the cooperation of all parties, I'm confident that the hearings will provide a fair and thorough process for the presentation of evidence required for this commission to be able to give the public the answers to which it is entitled.
Hello again, I'm Martin Stringer, and you have been listening to Justice Paul Rouleau from a little earlier today. He is the Commissioner of the Public Inquiry into the Trudeau government's invocation of the Emergencies Act. That inquiry got underway, its first day of hearings today. A little later today, if you want to see some more of that, at about 5 p.m. Eastern on Headline Politics, we'll be playing more of those hearings that got underway today. And you can hear some of the principal groups, the groups that have standing presenting their positions, and we'll be playing you a significant part of what you saw today. Also, that's available on video on demand as well as on the web on CPAC. Now, we are going to continue our Headline Politics coverage here on CPAC. We're going to shift our focus now to Russia's continuing war on Ukraine and the world's response. NATO defense ministers today wrapped up their latest meetings in Brussels, Belgium. They were discussing how to counter the Russian aggression and the latest commitments of more military aid to Ukraine. NATO members are pledging to ramp up the military production at home to supply Ukraine, but also to replenish their own dwindling stockpiles of arms. So let's listen in to the Secretary General of NATO, Jens Stoltenberg, who came out of those meetings and gave a briefing today in Brussels.
Good afternoon. NATO defense ministers have just met to address key challenges for our security. This includes stepping up our support for Ukraine, strengthening our deterrence and defense with forces, capabilities and stockpiles we need, and protecting critical infrastructure with more presence, resilience and intelligence sharing. We addressed Russia's brutal war of aggression against Ukraine. President Putin has responded to his failures on the battlefield with attempted annexations, partial mobilization, reckless nuclear rhetoric, and indiscriminate attacks on civilians and critical infrastructure. Together, this represents the most serious escalation since the invasion in February.